Well, good evening to all of you. Happy Thursday. Happy Thursday indeed. It's a little bit later than I usually am up and about on these live streams, at least starting these live streams, but I'm glad that you guys tuned in. To those of you on the replay crew, good morning, good day, good afternoon, good evening, and good night, and whatever time it is that you are tuning in to watch this particular recap. So, today we're continuing our recaps of the Take Care of Maya trial. This is the case of Maya Kowalski, well, rather, Maya's father, Jack Kowalski, Maya, her brother Kyle, and the estate of Beata Kowalski versus Johns Hopkins All Children's Hospital. This case was documented in the Netflix documentary Take Care of Maya, thus the Take Care of Maya title. Case involves Maya Kowalski, who was 11 at the time that she presented to Johns Hopkins All Children's Hospital in October of 2016 with a prior diagnosis of CRPS. She presented with acute abdominal pain, and shortly after her presentation on October 7th, the hospital became kind of concerned with some of the treatments that were being requested by Maya's mother, Beata. There was an intervention by the doctors that then contacted DCF. Maya was then removed from the care of her parents and sheltered with the hospital by order of the court in Florida. So we had a shelter order in place beginning October 13th of 2016. That shelter order was modified at various times until January 6th at a hearing where Beata was present with Maya. The judge denied Beata the ability to contact or touch or come into contact with her daughter. And then the next day, Beata unfortunately took her own life. As I have said at the beginning of all these recaps, because we're covering very sensitive subject matter, I do have a running banner that runs at the bottom, and I will put that up once we get going. That's just to kind of let people know that when they do tune in, the subject matter we're discussing. I don't want to catch people off guard with that. Before we get rolling today, I wanted to, well, let me do what I usually do. Why are you commenting on this case, Rob? Hi, I'm Rob. This is my channel, Law and Lumber. Thank you for being here. I'm a practicing attorney, practicing the area of domestic relations litigation. I have been for the past more than 10 years. So this case has significant overlap with the area of domestic relations litigation. So it's of interest to me. One of the things that I kind of wanted to talk about was some of you guys who might be following the channel might have known that I was in court today at a trial. So I had a trial in the Juvenile Domestic Relations District Court in Fairfax County. This is a court that sits in the same posture as the court in Florida that entered the removal order. So same kind of procedure, same kind of rules, same kind of things that we watch. Now, I had a trial today that was scheduled to be a 2-hour trial. It was scheduled to be 2 hours. And it was a very sensitive matter, as are all the cases that appear in that court. And when we appeared in court, so first of all, 2 hours is a short amount of time. The judges that sit in this court, I believe there's 10 of them right now, they hear all custody, visitation, child support, dependency, removal proceedings, juvenile crimes, crimes by family members against other family members for the entire county of Fairfax. So they have a maximum amount of time that they're giving you, which is 3 hours. That's the maximum amount of time that you can get for a trial in this court. Does that seem ridiculous? Yes. Because how can I explain to a judge enough background in a 3-hour time period where that judge is fully informed to make a decision about the life and well-being of a child? This is largely an issue of funding that we have with the court system because it's always NIMBY, not in my backyard. Unless it's something that they're dealing with on a daily basis or something that affects their life, a lot of people don't really care about these particular types of cases, but they have massive impacts on families. This particular case that I had today renewed a lesson in me. Well, it made me think about something because I'd been listening to the testimony a bit before I went. One of the first discussions I always have with a client is their priorities. I started doing this after a few years of practice where I started realizing that the young attorney in me was either go to trial, don't go to trial. And you get this inclination where you put your judgment and your priorities sometimes they can, if you're not careful, they come in front of your clients. So I started doing this practice when I meet with new clients is I want them to tell me what their priorities are. What are your priorities? And then based on that information about their priorities, I give them an assessment of the case all the way up until the moment of trial. And they always want to know percentages, and I can't give them accurate percentages, but I try to give my best assessment of what I think the likelihood of success for what they're requesting is. And I'm realistic with that because there's two parts to being an attorney. That's why we call them attorneys and counselors at law. The attorney is the advocate that stands up in court. The counselor at law is the person that advises their client. And it's your job to advise your client fairly and accurately and to conform that advice to their priorities. This is their life, not mine. They set the priority, not me. So we appeared at court, and I wanted to go forward with trial. I did. I wanted to put the other person on the stand, and I wanted to cross-examine them, and I wanted to go forward. But there was a risk. There was a risk that we might not get the outcome. And that risk, when the client balanced that risk against their priorities, we went to settlement discussions. And despite my desire to go to trial, despite the prep that I had done to go to trial, the hours of prep for a 2-hour hearing, I was compelled to advise that client appropriately with that perspective in mind, their priorities. This is their life, not mine. They make the decisions, not me. It is their right to make that judgment call. It is their right whether to proceed with a case or not. And the outcomes of that case might have a negative impact on them, their children, their family, but they have the right to make that choice. Why am I bringing this up? I'm bringing this up because there's been a lot of discussion in this particular case about the rights of parents to make decisions for their children. They have the right to make decisions for their children. Now, we might disagree with some of the judgment calls, but unless and until the exercise of those rights goes to a certain threshold where demonstrable harm occurs, and even then, sometimes even more than that, you have to respect the fact that they have that right. As an attorney, when I was presented with this, and that was kind of I guess the thought process I had today. There was a bit of disappointment in me that this didn't go to trial. But it's not my life. I gave the client the best advice I could. I gave them the ability, I gave them the knowledge to apply to their specific circumstances, and I gave them the ability to make not just a judgment, but an informed judgment. And they made the judgment that's best suited for their family. And you know what? I don't disparage them at all for that. It's their family. They set the priorities. I am just an agent that both advises them and advocates for them when we don't get to that ability to reach an agreement. We were able to reach an agreement today. That was great. It's great. But I just want to keep that, I want to put that in people's minds that when we're watching these individuals testify, when we're watching these trials, when we're watching these families, there's lives that we don't see. There are lives that we don't see. There are things that we don't understand, things that go beyond just what you're able to see in a courtroom, whether it's sidebars or not. And for people that sit here and say they have the right, or when I say they have the right, I don't mean they have the right to commit acts of abuse, neglect, or abandonment. They don't have that right. That's why the system is in place to initiate removal proceedings. And the courts move very cautiously in that. We're going to hear the jury instruction on the Department of Children and Families and the shelter orders that were entered. These are orders entered by a court that is identical to the one that I was in today. And when court enters an order, they enter it because they're exercising caution, and they say, we're going to continue it for a month because that's the next available date. Continue it for a month, continue it for a month, continue it for a month, next available date. And it moves slow, and it hurts the family. Court is not fun. I might talk about the theater of the courtroom, and there is a certain theater to it that I do enjoy. I like the 3D chess. I like the 4D chess. But I never forget, and I never lose sight of the fact that what we're talking about is families and people and their lives. I make that caveat also because I want people to understand that when we're watching this trial, all parties involved, whether it's Sally Smith, whether it's Greg Anderson, whether it's Mr. Shapiro, whether it's Maya Kowalski, I want people to recognize that these people have lives that extend well beyond the courtroom, lives that intersect with others, situations that we don't see play out in court. One of the circumstances with Dr. Sally Smith that you don't see in front of the jury give the context to some of the nerves that she presents when she first starts testifying. The jury would never see that. Judges don't see that. They don't know the context. We don't know what happens outside the courtroom. So I want to remind people, please give grace if you can. You should be able to. I've seen trolling remarks and comments in my feedback to these streams. Someone yesterday said, when I said I couldn't recap today because I had trial. Glad to miss your really biased opinion. Okay, that's fine. That's fine. Attack me. That's okay. I'm out here. That I got thick skin. You can't be a domestic relations attorney without thick skin. I think I wrote back. Glad you took a few minutes of your day to put some love out in the world. A couple keystrokes, man. Good choice. It's kind of what I think about when I cover these trials, when I see people engaging in the chat comments, etc. When the couple of people come in that are trolls. Not trolls. They have opinions that they express very loudly. And why? Why? Does it really make you feel that much better? Now, I have opinions about a lot of stuff that gets said today, and I'm explaining to you my biases ahead of time because, yeah, I have. Everyone does. When you see enough information, it persuades you to desire a certain outcome. Where I stand on this case right now is that there's a lot of weird things that get presented in court, but there's a few specific events that I can't wrap my head around. A few specific things that the hospital, I think, does that I still can't understand their explanation. I think there's a big gap in the plaintiff's case. I think the plaintiff's case has a gaping hole in it, and that's kind of the causation issue when it comes to Beata and that suicide count. But that's just me. People are allowed to have different opinions. The jury has opinions. They express it quite often. So that's kind of where I am with this. And I wanted to do that little forewarning before we got into it because, like I said, you guys see me on a screen. You don't see me in court. You don't see how I engage with my clients and the fact that these people trust me with their lives and their families, and that will forever have a massive impact on me. I will never forget that, ever. So just wanted to give that little forewarning. And let's go ahead and start getting into it, shall we? People have been asking what's the subscriber count because we've been marching towards 200,000. I don't know. I checked it later this afternoon just because when I was throwing the stream up. But let me see. Let me see real quick. I'll just pull it up so I can see what it looks like because people are asking. And I want to make sure. Oh, I did eat today. Because that case settled, I was able to make a shepherd's pie for dinner. It was delicious. It was delicious. That was it might not be the healthiest thing in the world, but it was delicious. And I have to be back in court tomorrow morning. So there's that. Got to be back in court tomorrow morning for a different trial because for some reason I double booked the trials. Not double booked, back to back. Double booking trial, big bad bet. So this is where we are tonight. Look at that. 199, 891. That's pretty cool. That's pretty cool. I think we're going to get to 200,000 before the end of this trial. Heck, we might do it tonight. Who knows? So you guys were asking, wanted to share. I think it's exciting. I think it's fun. I still have no clue what I'm going to do for the celebration stream of hitting 200,000, but we shall see. Caveat, because I have to be up early tomorrow for court, I will try to engage with chat and chat questions, but I have a lot of material to cover and I have all of my timestamps. So I have a lot of material to cover, a lot to get through, and I want to be able to get through it in a timely fashion. If I miss a super chat or I miss a comment, I will try to pull them up on the screen while we're going through some of the material. I appreciate the hell out of every single one of you guys that are here, all of you. There's been phenomenal gifted memberships. You guys have been most generous during the coverage of this trial. And I want to thank every single one of you for that. If it's a question, I'll keep it. If it's a question, I'll keep it and try to answer those towards the end. I'll take little breaks and see if there are questions that are relevant to a specific witness after we finish a recap of that witness. But I want to make sure that I'm moving stuff along because I get remarkably distracted. You'll see Celine in the chat giving commentary about how many times either the mic doesn't work for me or the squirrel distracts me or that I get a spinning wheel of death on my live feed and stream. So just want to kind of put that out there. We don't have closed captions today. That's a forewarning, but I do have the gain volumed up to about 600%. I'll turn my volume down a little bit while we get in the coverage. And let's go ahead and get into things. And I will go ahead and swoop before we do that. All right. So as you guys might have gathered, well, it was a boring day in court today. It was not a boring day in court today. Sally Smith, Dr. Sally Smith has taken the stand. Dr. Sally Smith is there. So you guys remember the deposition, right? Dr. Sally Smith works as a medical director of the child protection team. Also staff privileges at Johns Hopkins All Children's Hospital, JHATCH. So I was most curious about how we were going to tiptoe this line. Before Dr. Sally Smith took the stand, there were some letters from Maya Kowalski that were read and emails. I'll pull those up in a little bit. I do have them saved. Thanks very much to Calypson's Vixens, who's one of Recovery Addicts mods who gathered that and sent it over. So I'll pull those up. I think they're pretty favorable for the defense. They made me feel a certain way when I read them, when I saw them, and the jury saw them too. So before Dr. Sally Smith took the stand, the parties had a back and forth discussion. The judge has made certain rulings about what Dr. Smith can testify to. Chapter 39 immunity, certain things that she does in her investigative role as a contracted agent of the Department of Children and Families, the medical director of the CPT, the child protection team. What she does in her capacity as an investigator for that team is protected under Chapter 39 immunity. That's been ruled on by this judge. It's been ruled on by the Court of Appeals that has made that ruling. It came back down. So there's certain things that these attorneys know they cannot go into. This is a freaking tap dance. Watching these attorneys dance around what they are and are not allowed to get into with respect to this doctor's testimony was itself theater. This was 4D chess. This was remarkable. So let's go ahead and you guys have also heard me say deposition scarring is a thing. Deposition scarring, when a person has been deposed several times and the depos are really harsh and they appear at trial, there's a nervousness to them because they've already been deposed. They've had a lawyer grill them over questions that they never thought would be asked. So there's a certain amount of scarring that exists, that they have a reticence reticence. Yes, reticence in their testimony. They're cautious. They seem guarded. It can come off as evasive, and I coined it deposition scarring. And I see you guys saying the banner. I'll pull it up. Here it is. Depo scarring. Well, if anyone didn't think that Dr. Sally Smith didn't have deposition scarring, kindly observe the binders that she puts on this witness stand. She has been grilled. So let's see. Two binders. I think that was two. That's two and three. Three binders. There's three binders. 4. Oh, we got more. 5. 6. 6 binders.
Morning.
6 binders.
Tell us your name, please, ma'am.
Sally Marie Smith.
And
6 binders. If you don't think she's been depo scarred about having documents at her disposal and being able to reference things, my word, 6 binders. Just in case they asked her about anything that has been testified to throughout the entire course of the trial or any part of this medical record. She has given 5 prior depositions before taking the stand here. 5 depos. Jeez. I mean, that is something. So she gives her intro. I'm not going to cover that. I just wanted to cover the binders. Gives her intro and her background. And we get an early objection that I kind of wanted to cover. So let's go into that. Let me do this and take my volume, turn it down a bit. So that I can turn the volume up on this. Let me see if I have this gained up. Yep, gained up all the way. Is it? It is. No, it's not. Why are you not gained up? Come on. I need you to be gained up all the way. Hang on. Why are you so quiet? That's annoying. Let me see if it fixes if I do one of these things. We can do this. All right, I think this should work. So let's see.
Just where I still am.
Okay. Let me back up a little bit there and try to clarify a couple of things. You indicated you resigned from all what was then just All Children's Hospital,
Right.
no Johns Hopkins,
Right.
in 2002. Is that right?
Correct.
And at that time, you became the director of the child protection team for Pinellas County, correct?
Right. The term they use for the physician is the medical director. So I was the medical director. Yes.
So, what is a child protection team, and who constitutes it? Who were you working for at that time?
So the child protection teams, Florida has a kind of a model program for the country, and it was set up in the late 70s. I think that All Children started.
Objection, Your Honor. This is beyond scope. Move to strike.
Well, that caught her off guard. Yeah, that caught her off guard. Why did that get an objection? Because she was testifying to Florida Department of Florida DCF, Department of Children and Families, and she was testifying to the model generally and how the model works and how the structure of the model works. Well, that's not an issue that she can testify to. That's an issue for the judge to instruct. The judge gets an instruction. The judge instructs the jury on the law. So the jury gets informed of the law from the judge. This is outside of her wheelhouse. She can't testify to this. It's a generality. And when she goes into this, Florida has a model and goes there. For me, I was surprised that she was this quick in responding to an objection. I mean, I'll rewind it a second, but whoa. And yeah, so and I did see this come in, and it's a point to make. If you hear her nervous, so on her way into the courthouse, she was confronted. Thank you, Casey Cat, for saying this. On her way into the courthouse, she was confronted by a John Stewart, a man that was jailed for 300 days for child abuse because of Sally Smith and Jay Hatch. He was exonerated, but's fighting for criminal charges against her and is suing her and Jay Hatch. So another person, while she is approaching court, she actually got lost. She went to the uh, town hall, city hall, whatever you want to call it. She went there, the government center, instead of the courthouse. So she's rushing to get to court, gets out of her car, grabs her 7 binders, however many things she is, and is walking into the courthouse and gets confronted by this person who immediately starts shouting at her and confronts her. That would throw me off too. I might be breathing a little bit heavy, and then she immediately gets instructed by the lawyers on what she can and cannot talk about. So yeah, like I said, we're going to give grace. I'm not going to be too critical of how she opens in her testimony here. And thank you, Casey Cat, for bringing that up. Very much appreciated. But let's rewind and see what that little objection was and how that kind of caught her off. So,
Or at that time.
So the child protection teams, Florida has a kind of a model program for the country, and it was set up in the late 70s. I think that all children started.
Objection, Your Honor. This is beyond scope. Sustained. Move to strike.
Sorry?
Sustained.
listen to how long Hunter takes to ask this
Can
question.
we approach him?
Sure.
He wants to approach because he's going, how did that bring an objection? So when I say these lawyers are tap dancing already, they're tap dancing. They're trying to figure out what they can and cannot say, and they're walking a very, very tight rope of information, like what can be testified to and cannot be testified to. And while the spinning wheel is going, I'm going to keep talking. So a lot of things could and could not be said during this particular trial. DCF, Chapter 39 immunity. This is going to drive me nuts. I tried to download it, but I couldn't download it. And I wanted to see if the closed captions would come in. So this is my fault. There we go. So let's see, come back from this. There we go.
2002 in one role or another.
Correct.
And tell the jury, if you would, what a child protection team is.
Okay.
Objection again beyond scope.
No, she can answer that question.
So in Florida, each county is covered by a child protection team. It's a multidisciplinary team that includes a medical director, usually nurse practitioners or sometimes other physicians from the county who are supervised by that medical director, and social workers who serve as what are called case coordinators. So they communicate with all the people involved in a particular investigation or case. And they also have like a teen psychologist, for example, that's contracted, a teen attorney, I believe. So it's a multidisciplinary team with these members, and it provides, especially in Pinellas County, one of the biggest functions of the child protection team is to provide medical evaluations when there are allegations of child abuse and neglect. And there are certain criteria that are set up under statute in terms of which kinds of situations warrant a medical evaluation. And so we kind of follow that list, if you will, in responding to requests for evaluations. The vast majority of the time, the request is made by the Child Protective Investigation Division under the Department of Children and Families. The child protection teams are under the Department of Health in Florida. And so they work side by side, but DCF doesn't run the child protection teams. And so they request for us to help them in investigating their case by looking at the medical information and guiding them in terms of whether there's medical evidence that would support a diagnosis of child abuse and neglect, and whether a child's safety is at risk as a result of that.
So in any given situation of a child abuse investigation, what is the role of the child protection team and its medical director in pursuing that investigation or facilitating that investigation?
So primarily the role is to provide that medical evaluation, and it kind of varies exactly how much work is required to do that. But also, we end up being a go-between on with the dependency attorneys, the child protective investigators, the detectives or law enforcement that may be involved in a case, again, to provide that medical expertise to assist everybody in making a good decision for the child. We present information in court on a fairly regular basis and assist the dependency judge or the juries in evaluating the cases for whatever legal action may be needed. And one of my roles, which is also in statute, is to provide education for community medical providers.
Yeah, that
So
was
in that role, particularly for a teaching hospital like Johns Hopkins All Children's Hospital, it's important. The residents are required to have a certain amount of training in evaluating child abuse and neglect. And so over the years, I've been involved in that element as well to help provide education for the medical students and residents there at the hospital.
And do you, or do your statutory duties as medical?
So that's going to bring an objection. She can't, her statutory duties, right? This is something that, again, this is the law, and it's a fine line that they have to walk, and Hunter's trying to walk it, and he really is trying to comply. And the judge makes a comment towards the end of today about how much the judge appreciated the fact the attorneys walked that line appropriately, that they didn't overstep, that the objections were not overly abundant, that they actually, the questions were very limited. I was very surprised. I thought this was going to be a lot more in terms of fireworks. And again, caveat, I know there's a proffer coming, and I'm going to reverse myself when I get to that proffer. She presents well. Her explanations are offered to the jury. She doesn't seem to, I mean, this is a pretty stark contrast to the person that we saw in those deposition tapes, right? I mean, look at that. The depo tapes that we watched, that was a person that was irritated, agitated to be there. This is a person who's explaining a case to the jury. She does a good job in this. This is someone who's testified in court over 300 times. She knows that the jury is there. She knows that the jury is her audience. Now, when the jury's out of the room, you see a very different person. But when the jury's there, she does very well. I was very impressed with how well she navigated. She gets caught off guard with the objections, but she does well. She does very well. She's directed herself to the jury. She did very well. On the element of coaching, I don't think coaching came from defense counsel. I think coaching came from her own counsel of, hey, be careful. Don't step in this situation, A, B, C, D, E. You know, I think that was from her own attorney, not the defense attorneys. So, and no, why would she look in Jack's direction? She can't. She has doubled down. She really does believe her position, and she testifies emphatically to it. So her attorney, because the question Anderson asks at the very beginning is whether she's spoken to defense counsel. And she said, no, I believe that. I think she talked to her own counsel.
You may continue, Mr. Hunter.
Thank you, Your Honor. May it please the court. Let me focus this a little bit.
Okay.
In early October of 2016, did you receive a call regarding Maya Kowalski from Dr. Beatrice Testifies?
Yes, I did.
And at that time, when you received that call, did you have any knowledge of Maya Kowalski or her admission to All Children's Hospital?
No, that was the first I learned of it.
Okay. And Dr. Testifies contacted you regarding concerns that she had?
Yes.
And what did you do to tell us very specifically, and not at any length, if you would, what you did in response to that phone call?
I talked to her on the phone about, she was asking me about what to do about a possible case of, I believe her terms were Munchausen syndrome by proxy. And we talked about the kinds of things that are needed to assess that diagnosis, such as medical records.
Objection as to what?
You can continue. Mr.
Good. Sorry.
And we also talked briefly, as I recall, about this specific case. And I tried to give general advice in terms of how pediatricians can approach concerns for Munchausen syndrome by proxy, or what I prefer to call medical child abuse.
And
This is before the DCF phone call. Okay, contextually and time wise, this is that initial phone call before the DCF call. So right now we are in treacherous waters of whether she's acting, because the phone call to DCF is what triggers her capacity and her authority to basically the phone call is what triggers her authority and her investigatory powers, right? So she has to be tasked with the investigation. This is preliminary. This is a call from the doctor, not from DCF. So context.
were you called at that point as a member of the child protection team or as a medical staff member at Johns Hopkins All Children's Hospital, or do you know?
My understanding was I was being called as the person they all had known for 32 years to be the hospital expert in child abuse and neglect as an active medical staff member, and another active medical staff member was seeking my assistance, advice about what to do about a case where there was concern.
I was very surprised by this answer. This caught me off guard. She was contacted in her role as a person whom the hospital trusted, in her role and in her capacity as someone with staff medical privileges. So right there, you don't have the call to her in her capacity as the medical director of the child protection team. You have her, and this is kind of her acknowledging the hospital called her because she was a part of the hospital in some way. She's waffly about it, but when the jury is thinking in their mind that she's a part of the hospital, that was interesting to me. I was curious about that answer. I don't know if Hunter expected it or not. So, like I said, I was fascinated. And then I'll get to the access stuff in a second. Come on, YouTube. You need to do better right now. You really need to do better.
Now, with calls such as that, would that be considered a consultation?
That would be my understanding of what that's what I thought it was.
Did you access the medical records from Maya Kowalski at that time?
I believe I did briefly. Yes.
And did you take any further action as far as evaluating the patient herself and her medical care at that time?
No, because to do anything as a child protection team medical director, I need to be asked by investigators to provide a medical evaluation. And at that time, to my understanding, there was no actual investigation ongoing yet. And Dr. Tepa Sanchez wasn't the person under Florida law who can ask me to provide that medical evaluation.
All right. This right here is the one area where I think her testimony in front of the jury became quite problematic. This part here. And a lot of people had a lot of opinions about this when I was watching on various different streams. People said, well, she has staff privileges. She can look at records. No. She can when she's engaging in a function that's a proper function and a proper use and a proper access of those records. Best example for this one is, for example, if I'm a cop, right? And I can walk into your house, but I need a search warrant to do it. Just because you have the ability to access something, like the physical capability of accessing something, doesn't mean that you have the legal right to access something. And in the context of medical records, staff privileges get you the ability to look up different medical files and the records of different individual patients. But it doesn't mean that you can just go and look it up. If you're a county clerk and there's a sealed record, right? So county clerks have access to everything within the court system. But if there's a sealed file in a case that you did not seal, that you didn't do, you can't go poke around in that. That's unlawful. That's illegal. You can't do that. Just because you have the capability of opening those things doesn't mean that you have the right to do it. And people were citing different exceptions to this, but I don't think these exceptions apply. Now, I want you guys to be mindful. She settled out. So Suncoast settled their case with the Kowalskis. I think it was $2.5 million settlement. So this is something that I think was this is a big issue that she has. And I'm speaking from the legal perspective. You do not just have the right to jump into medical records and then give advice based on those medical records. You're not allowed to do that when you're kind of stepping outside the scope of your authority. And then she goes and explains that she didn't investigate further, but she already kind of did. Do you see how she kind of glanced over that? She just kind of scooted past that. I looked at them briefly. And then she explains that I didn't have the authority at that point in time because there wasn't a call made. And then she goes into the fact that the call is what actually gives her the authority to begin the investigatory process, while kind of bypassing the notion that she had just looked at the records. Like that was, you went real quick over that part, Dr. Sally Smith. You went real quick over that part. So, like, I get what you're saying. You just really flew past the part where you shouldn't re-access them.
So it was a Saturday, as I recall, 1-ish in the afternoon, and we had a little discussion at that time. And then I honestly didn't think about it more, do anything more about it until Monday when I got that referral where the child protection team was asked to provide a medical evaluation.
Let me give you a police officer example, a cop example. This is a good one. Here's a cop example. Let's say that I'm a cop. Okay. I'm a police officer and I am walking around your house. I'm walking around your house. And you know what? I think that you have drugs in your house. I think you have drugs in your house. Someone called me and said that you have drugs in your house. But before I do anything, before I go to get a warrant from the magistrate, before I do that, someone called me and said you have drugs in your house. So you know what? I'm going to take a peek. So I open the door, walk inside, and I see a baggie of drugs. Whoop, there's a baggie of drugs. And I go back outside and I continue walking around. And then I wait until, I get a call that gives me a warrant that may or may not be based on the information that I had beforehand. Right. So I get a phone call that says there's drugs in the house. I walk inside. I see a little baggie. I come back out. I talk to the person who made the call. I said, oh, yeah, there's drugs in there. There's drugs in there for sure. I saw him. I touched him. I felt him. That person then goes and calls a magistrate. And now I have a warrant in my hand. And now I go back and enter that home with the warrant. Do you guys see a problem there? Do you see a problem there? I do. I see a very, very big problem there. So and people are asking, Creed, this is a very good question. Isn't that a thing for the dependency court? No, it's not. This is outside the scope of that dependency proceeding. This is actually why we're in trial. This is why we're in trial with this particular issue, because you couldn't bring this up in the dependency proceeding. This is separate. This is separate and apart from that. This is someone acting independently. So I had an issue with that particular answer. Let's go to the initial interview because I'm wary of the time here.
In early November, probably between 5 and 15 minutes each time. Those were the only times I ever saw her while she was in the hospital.
And what was the purpose of your seeing her those two times?
So part of my medical evaluation is supposed to be a physical examination. So when I saw her on October 13th, I was trying to perform a physical examination, which basically she declined. So in November, again, as part of my job as the child protection team medical director, I'm supposed to do a physical examination, and I'm also supposed to provide photo documentation for investigators and whoever else is involved in the case. So I went that day in early November to try to take some photographs of her lower extremities in terms of trying to essentially document the absence of a problem.
And did you take any such photographs?
I did not.
Did you ever interview Mr. or Mrs. Kowalski?
I took as part of my medical evaluation, I took a fairly extensive history from Mrs. Kowalski and a much more abbreviated history from Mr. Kowalski. The meeting with Mrs. Kowalski took place on October 11th, 2016, and the relatively brief interview.
Do you think she's
Her
approached by her
history
attorney?
taking with
Sorry, Dr.
Mr.
We get you
Kowalski
better.
occurred on October 13th.
There we go. Better pause. Do you see how careful she is when she gives these answers? Every answer has and this is good move by her attorneys. Very good move by her attorneys in prepping her. Very good. So the prequel to every answer she gives as a part of my medical evaluation, as a part of my medical evaluation, as a part of my medical evaluation, every question she answers with as a part of my medical evaluation, that is to lay context. So she is saying, in my capacity as the medical director of CPT, in my capacity as that is what that translates to. Every single answer. Every answer. So in my capacity of the as a medical director of the CPT. So this is getting into the interviews. And no, she didn't do this in her depot. I don't know if she knows that the depot was played. She's not supposed to know. She's not supposed to know the depot was played. So we shall see. Because right now the jury has a stark contrast between the deposition that they heard and what's being testified to in court. We'll see if they pick up on it. We'll see if YouTube picks up on the stream.
Did you ever speak to the two of them together?
I did not.
When you spoke with Mrs. Kowalski, first of all, where was it?
So at that time, Maya was still in the pediatric ICU. They have a family conference room kind of thing outside of the main entrance to the pediatric ICU. And because of the investigation that was being initiated and everything, I scheduled a time where the child protective investigators and the people in law enforcement that were investigating the case could join me to while I took my medical history. So there, as I recall, there were about 5 of those people, 2 or 3 child protective investigators, I think 2 law enforcement people, and Mrs. Kowalski. They were all in that room already when I got there for the scheduled meeting, which I believe began at 5:45 in the evening on the 11th.
Doesn't this sound different than the depot?
Did you identify yourself to Mrs. Kowalski?
Absolutely.
How did you identify yourself?
I always say, I'm Dr. Sally Smith. I'm a pediatrician with the child protection team.
This drives me
And
nuts.
that's what I said to her.
Did you catch her answer to that? She did this, and so did the nurse. I always say, and how did you identify yourself to Mrs. Kowalski that day? I always say this. That's not an answer. That is not an answer to the question. The question is, how did you do it that day? And the jury has the deposition. They have the deposition, which is different than what she just described. Very different than what she just described. So those two things are remarkably contradictory. So I always say, hi, I'm Sally Smith. I'm with the child protection team. That is not how she described it in her deposition. So that bothered me a lot. And the answer that she gave to the jury with a smile, and I'm wondering, I don't even have to wonder. I know this jury's been paying a hell of a lot of attention to a lot of stuff. There's no way that went unnoticed.
And the other folks who were there were either law enforcement or child protection investigators?
Yes, it's possible one of the nurses was in there, but otherwise those were the people that I recall being present.
Okay. Were you wearing a lab coat?
No.
Do you ever wear a lab coat at all?
Well, at All Children's, no. I do in my office now since the pandemic, but
You guys remember her deposition? Do you remember her deposition that was taken in, I think, 2021 or 2022? I don't even own a lab coat.
but for 20 years, I never wore a lab coat.
Do you wear, when you're in a hospital, do you wear a particular identification badge?
Yes, I have to wear my Johns Hopkins All Children's identification badge to come in the door and to, move around. There's all these little things you put your badge up to open doors. And I have a similar one for Bayfront.
Okay. So if you're in Bayfront, for example, you wear a Bayfront badge. If you're at All Children's, you wear an All Children's badge.
Correct. And when I go in between, I switch badges.
Okay. When you spoke with Mrs. Kowalski, was there any question that you had identified yourself as a member of the child protection team?
Absolutely none.
And did you conduct that investigation in any way as an employee or agent of All Children's Hospital, of Johns Hopkins All Children's Hospital?
No.
Did you ever hold yourself out to Mrs. Kowalski as acting on behalf of Johns Hopkins All Children's Hospital?
No. As I said, this was a scheduled meeting. Everybody knew exactly what was happening.
Did Mrs. Kowalski know?
Absolutely.
How do you know that she knew that?
Objection, speculation.
Sustained.
Are you aware of how Mrs. Kowalski might have known that this meeting was going to take place?
As I said, they were all in the room when I got there. So she, and I believe some of these people had already interviewed her as part of their investigation. She probably recognized some of these people. They got on their badges and their, work-related clothing and things like that. So,
Objection, again, speculation.
Overruled. She can say what she saw.
Yeah.
so, and I introduced myself. I don't quite see how it's possible that she didn't know who I was and what was happening.
How long did that meeting take place?
About an hour and a half.
And you subsequently had an opportunity to speak with Mr. Kowalski?
Yes. So,
I'll
Okay.
follow up on that. When did you talk with Mr. Kowalski?
so that was on,
We're going to fast forward a little bit. Because Hunter brings up a exhibit. I don't think. You guys tell me if Hunter expected this answer when he brings the exhibit up. First of all, I watched this testimony. This is now my third time watching this. The first time I was surprised at some of the answers. Second time, I was skeptical of some of the answers. Third time, I'm looking at this again and going, oh my God, if I had that depot and I could play the two side by side. Like if I had the deposition and I could play the two of them side by side, which I think I'm going to try and do. I'm going to try and clip it and see if I can't find out, because she testified really well in front of the jury. If the jury doesn't remember the depot, she testified really well. She looks good.
Okay, please go ahead. Thank you, Your Honor. Going back to this exhibit, had you asked to meet with the treatment team at this meeting?
no, I was making that request in my role as the medical director for the child protection team to assist with that side of the situation.
Okay. Were you a member of the treatment team?
No, and I didn't attend this meeting.
Oh, you wound up not attending this meeting?
It wasn't for me to be there. It was for them to have the discussion.
And you wanted to know what their consensus was. Well, I mean, sorry, never mind.
Did he know? This is a question. Did she admit to attending this meeting in the depot? Did she? Because this exhibit came up and then she said she never attended the meeting in this testimony. Hunter takes a long pause here. I do not think that he. Oh, does she admit to it on cross? Hunter did not expect this answer. But she says it so confidently that she didn't attend this meeting. Oh, and Hunter can't correct her because you're not allowed to impeach your own witness. He can't correct her. You cannot impeach your
Did
own
there
witness.
come a
You
point
cannot
at
make your witness
which
out to be a
you
liar.
became aware of any pictures or videos being taken of mine?
Yes.
And tell us,
Okay, let's go to cross. Here we go. 151.30. Okay, Mr. Anderson's doing cross. That was weird. That was really weird.
Considered at this point by Dr. Tepa Sanchez as the go-to person for Johns Hopkins insofar as the,
It's the same.
have you ever heard that you were referred to as a go-to by the doctors there?
Well, they wouldn't be saying that to me, so I'd have to say no. I don't know what they say amongst themselves.
Okay. Now you said though that you weren't a part of the treatment team. Did I understand your testimony?
I was
That's right
not,
here.
correct.
We bring up 1002-0005. Next to last paragraph, bottom sentence.
I'm sorry. Oh, okay. I see at the very top,
The last.
barely see the discharge summary note. Okay,
All right.
okay.
Now, you weren't and didn't have any training in psychiatry, right?
Just rotations in medical school and residency.
You were not a pediatric psychiatrist.
Certainly not.
You were not a pain specialist.
No.
You were not an anesthesiologist.
No.
You were not involved in rehabilitation medicine.
No.
But you were included nonetheless in this treatment team, were you not?
No.
Let's go to 002-0006. And let's look at the bottom paragraph, third line. I think it's the last of the second and top and the third sentence. Nope. Above.
Well, that's a note.
No.
Sally Smith were all involved, all heavily
This is
involved in
at
her care.
0006. And
Oh, interesting.
I'm looking for the. All right. So Dr. Sally Smith was heavily involved in her care. Is that true?
As the medical director for the child protection team in a complex medical child abuse case, yes, that's correct.
Well, you were involved in considerably more than that, were you not?
In her
Not in any type of day-to-day treatment of the child, but certainly in a role coordinating some of the elements related to the investigation in the court case.
Well, getting Maya Kowalski off of all of her medications is not part of your job with CBT, is it?
Well, so
Is
that
it,
was,
isn't it? Yes or no?
excuse me, Honor,
As soon as she says yes or no to whether it was or was not part of her
Why
job.
don't you answer the specific question? If you need to explain, you can start explaining.
I'm sorry, could you just state the question again one time?
Sure. Well, deciding what medications Maya Kowalski should be on or whether to take her off of medications is not part of your job description at child protection, is it? Or was it?
The
Is that
part
yes
about,
or no?
yes, but I have to explain.
Yes, it's part of your job to do that, to manage Maya Kowalski's medications.
May I explain?
Well, yes.
So the part that was part of the question was related to taking her off medications. In cases of medical child abuse, one of the things that is important to try to do in a controlled setting like a hospital is if a child is on medications that may not be necessary, that the treatment team would consider to wean those medications in that controlled setting.
All right, so were you part of the treatment team or not?
I guess it's sort of threading the needle. I wasn't writing any orders. I didn't tell them which medications to stop or wean or
Dr. Sally Smith, it's like threading a needle. You don't say. Like you don't say it's like threading a needle. You don't say that there's the muddy water between whether you're acting as a treating physician or in an investigatory capacity. You don't say that there's a little bit murkiness in between what role you're playing and what role you're not playing. And it's the blurred lines here. And the hospital has acknowledged it, that the blurred lines here cut disfavorably against the hospital. They just do. I mean, the judge has acknowledged it, the hospital's acknowledged it. And now Dr. Sally Smith is up here going like, oh no, I was kind of threading the needle, trying to make sure that I wasn't treating, but was investigating, even though it said I might have been treating. Ah, hmm, hmm. So, now you can see why this case is in court.
or anything like that. But as part of the whole evaluation of medical child abuse, there's a component of what happens when they aren't getting all these medications. And so that specific little part of it was within my role.
Exhibit 2116, please. Now, you just told them to get her off as many medications as possible. Down, number 15, next to last from the bottom. I think there's a misspelling there, but we can agree.
And I believe the legal
Is that
term is
a text
read.
from you? To
Yes, it is.
Apologies?
Yes, it is.
Apologies that testified, no, you wouldn't know. Probably already, but is that as many meds? It just says meds here, but it's supposed to be meds as possible?
Yes, and her reply is the last one's going off today.
Okay. So were you or were you not advising the treatment team, as part of the treatment team, to take Maya Kowalski off of all of these medications?
I was assisting them from the standpoint of the medical child protection team, medical child abuse realm. And as the reply makes it clear, they were already doing it and I didn't even know they were. So certainly wasn't directing that process.
You didn't know what they were. Weren't you involved in Maya Kowalski's lab results as well?
I'm not sure what you're talking about.
Exhibit 1001-0317. On November 15th, 2016, with Dr. Pagan, as part of the child protection, the treatment team, did he consult with you about an extensive chart review and recommendations?
So again,
I'm just asking whether he did or didn't.
well, clearly, I believe I had some discussion with Dr. Carroll, who this is, she's one of the hospitalists. And so that's her note. So clearly we had some discussion about documenting that certain lab tests presumably were now normal that had been abnormal, but I didn't order the tests or anything like that.
Are you saying that where it says in a progress note in the Johns Hopkins records, which you say you have access to, right?
Yes,
It says that the treatment team leader spoke at length with Dr. Sally Smith, you, right?
yes,
That you had done an extensive chart review, right?
yes.
And you were making recommendations regarding lab tests, right?
I was from the standpoint.
And you were making observations of.
Let me tell you how she's supposed to answer this question. People beat me up on this comment all the time when I make these comments about what is she supposed to do? What is she supposed to do? Let me tell you what she's supposed to say. Let me tell you what the proper answer is to be here. Like, really, let me just tell you what the answer is that she's supposed to give. Once she is called by DCF, her role is that of investigator. She is to ascertain and obtain information that could tend to prove or disprove medical child abuse. Obtain and gather information and put a report together that is then a recommendation not to the hospital, to the judge, who makes the judgment call of what treatment is or is not proper, because this is now in the jurisdictions of the court. The proper answer to these questions when she is called or being informed as to the medication or the treatment decisions is to say, thank you for the information. I appreciate you keeping me up to date. I trust your judgment in deciding how to treat. I will let you know if anything changes as a result of DCF action. That is the appropriate response. That is what her role is. This muddy lines thing, that is her creation. That's the hospital's creation. That is their creation. Her role is clearly defined. She investigates and advises DCF, and they go to the court. They go to the court because DCF doesn't have power to act unilaterally. DCF has a lot of power. DCF doesn't get to jump in there and just say, nah, dude, remove the meds. They can't do that. They have to go to a court for permission because you know what? We trust judges to make these judgment calls because people have due process rights. They have the right to appear in front of a judge to present their side, her side, his side, whoever's side. They have the right to present that information to the court, and the judge, who is tasked with the oversight of all of this, says, this job sucks. I hate being a judge and having to make this call. I really hate being here. You guys think you think that I think this job is easy? It's really hard. Judges are no, it's the judge that makes that call. Or it's the judge who delegates the decision making. The court delegating with oversight. So no, this blurred lines thing where she keeps testifying to, this is a problem. And she keeps trying to say that this is part of my role because this. It's not. It's not. She doesn't have authority to make medical decisions until a judge says that she can. So when people come in and they accuse me of having a biased take on her testimony or how I'm biased and I don't agree with her and that this is blah, blah. Yes, I don't agree with her because my God, no, we don't trust administrative appointees or agents to make decisions without judicial oversight. Judicial oversight is there for a damn reason. The doctors did testify that they made judgment calls without her influence, but here she is exerting influence. How do you know? Yes, the doctor testified. I wasn't influenced at all. If someone tells me when I wake up in the morning and they say, you know what, Rob, the color yellow is a good day. I can go about my day and I can say that I chose a yellow shirt. That was my own voluntary choice. I chose that yellow shirt because it was not suggested to me. It was my own independent thought. But do you really think that someone telling me yellow is a great color, Rob, doesn't have an influence on that decision? So I have an issue with all of this testimony, every ounce of it. She did. She brought it to a judge. You're right. She brought it to a judge. She did. She brought it to a judge. And she did a whole lot of things without judicial authority. She brought it to a judge, but she also did a whole hell of a lot that a judge did not specifically authorize her to do. I have a problem with that. I understand she's an expert. I understand that she can probably do a hell of a lot better at diagnosing medical child abuse than 95% of other normal humans. I get that. Just because you have this belief that something that is happening is wrong does not give you the ability to bypass judicial oversight and just do it because you know better than everybody else. Even if you do know better than everybody else, even if you do know better than everybody else, it doesn't give you the right to bypass the system that is in place to maintain checks and balances and to maintain the due process rights of all of the people that exist in this society. So you're damn right. I have opinions about her testimony. You're damn right. And how she makes it so, she makes it sound so simple which is great. This is a testament to the prep that she did and the fact that she's a very good witness. She's a damn good witness. Because she makes it sound so, she effortlessly speaks to this. And she does a great job explaining it. She was good for the hospital today. But what bothered me was how casually she spoke about something that I take such significant offense to. So, God, oh man, this killed me because it was so casual. It was just, you know, just normal Tuesday. Just normal Tuesday. I mean, this is wild. Do you have any idea what this would look like if it was a police officer? Or if it was an administrator at a school? I know some of you probably do. If it was an administrator at a school, do you have any idea what this would look like in those capacities? I do. I've seen it. This is scary. This is scary. Golly. This doesn't scare you guys. For anyone with kids, that goes to school or that engages in the public. If you have a teenager that's out in the public with where police officers are interacting with them, if you have people that are engaging, I mean, this is whoo. Just take that. When I give these examples and when you guys are when you're grilling me about all of this stuff, I want you to take a step back and imagine what this behavior looks like when you take it to its logical conclusion. I know that people have opinions about the ketamine use and the coma, and I have opinions about it too. I think it was I mean, the doctors have been eh, you don't have to convince me very much. I get concerned about a lot of the stuff that they're talking about, but there's the thing that I get around. What I was talking about is we can have disagreements on what the treatment was and whether it was or was not permissible. I think the hospital's kind of protected there. It's this. It's this right here. I have made comments about I don't think this is a med mal case. I don't think this is a medical malpractice case. I think this is a case that's based on false imprisonment, all the other stuff that's extraneous to the medical malpractice stuff. KBL, I see in the chat. Consider that the hospital saved Maya's life. Okay, okay. To me, that does not justify this conduct. That might sound crass, but there's so many things we don't know of what could have happened if she had gone, if she had gone, if she had gone by the book. Couldn't we have reached the same result, hypothetically speaking? If she had gone by the book, couldn't we have reached the same result? That's the problem. If she had gone by the book, yeah. Yeah. That's the problem I have with it. So then we get to one of our favorite parts, jury questions. And they, of course, do the jury questions outside the presence of the jury, and they do a sidebar to discuss it. Well, you know who has access to the Zoom feed, who I just saw pop up in chat. Where are you, bud? I saw you. Recovery Addict. Before you guys make comments about can he broadcast this, he can. He has every right. He has permission to access the Zoom feed. The permission to access the Zoom feed means that he cannot rebroadcast the audio directly, but he is allowed to repeat, just like every other reporter in the world is allowed to repeat what they see in court. Unless there's a gag order, there is no gag order in this place. He is allowed to say what is being discussed at this sidebar, and he has a very good knack for listening in and relaying the information that we get to hear. And people are saying bring Recovery Addict in. I would love to. I'm going to get with Scott at some point in time and do a stream together. He streams all day long. He streams this case all day long. Plus, he had a date night with his wife tonight. Good for him. He streams all day long. I have a very limited period of time at night where I can bring this stuff. After this case is done, I'm pretty, and maybe during deliberations, he and I will probably get on a stream together and chat, because I would love his take, and he's done a great job covering this case. But if you guys are wanting to watch this live, please go check it out at Recovery Addict. He does the Zoom feed. So when the judge says jury leave the room, some of these sidebars, the judge hits mute for the audience. Like the people in the courtroom can hear what's being discussed. They can hear what's being discussed, but the judge hits mute on the national broadcast feed. So because Recovery Addict is technically in court because he's on the Zoom feed, he is allowed to report on what's being said in court. So let's listen to some of the dialogue, that was being discussed during this sidebar.
Dr. Smith is out of our presence. Let's start. Red number 1. Do you know why it is the hospital's policy to contact you first instead of reporting the suspected abuse to the child abuse hotline? Correct me if I'm wrong. There is no harm in contacting the hotline prior to contacting an expert first. That's against court decorum, James. I can't do that. I've agreed to certain terms to have access, and the judge has proved that. No objection from either party. Judge is trying to read this next one. Red number 2. How would CPT normally access the medical records? Next question. Do the county CPT have access to medical records normally without privileges? No objection, says Mr. Hunter. No objection, says Mr. Anderson.
Kurt, are you sniping my stream right now? Uncivil Law, are you sniping my stream? As I'm sniping Recovery, is this like a window within a window within a window? So, yeah. Hi, Kurt, and everyone watching on Civil right now who does a Thursday night stream.
Red number 3. Are the physicians that are part of the child protection team required to have privileges at a hospital to provide a medical assessment? If yes, do the privileges grant access to patient medical records? If no, what procedures would a CPT physician follow to obtain medical records? Next question. Is it standard for a CPT physician to offer any recommendations to a child's treating physicians in a suspected child abuse case? Silence. No objection, Your Honor, says Hunter. No objection, says Mr. Anderson.
I'm going to speed you up a little bit, Recovery Addict. We're going to go 1.5, Scott.
Says the judge. Mr. Anderson said, actually, no problem with 1A and B. 2 is a bit beyond the scope there for her to testify about the rules and procedures for all CPT positions. I'd object to that. So he changed his mind on that. So we have one objection from Mr. Anderson. Mr. Hunter said, you made an issue of it. I think it's within the scope of her expertise. I suspect with the scope of her knowledge, and C, that's a follow-up on certain of counsel's questions. Mr. Hunter said, I asked broadly. Judge says, I believe that this question is it standard for a CPT physician to offer any recommendations to a child's treating physician when a suspected child abuse case is covered, whereas within the questions that were asked, and I think it actually goes to the question of whether Dr. Sally Smith was operating in her capacity as the medical director or somehow an apparent agent of the hospital. So I will overrule the plaintiff's objection and ask that one. Red number 4. Who made the referral to your CPT team for the evaluation? When you told Dr. Dees to get Maya off as many meds as possible, did you know that was already in progress prior to telling Dr. Dees to do so? Were all the meds or outside treatments being investigated, parentheses, with regard to the Munchausen suspicion, in parentheses, being administered and provided by Beata or other medical providers? Mr. Anderson says something problems with that one. I'm not sure if it was no problems with that one. Now Mr. Shapiro and Mr. Hunter are looking at it. Long pause here. No objection, Your Honor, says Mr. Hunter. Mr. Anderson comes in and says no objection to the first. The second one raises this is Whitney, raises the 403 issue regarding medications that were being administered and provided by Maya Kowalski. If we want to strike Beata, we would not object. But Dr. Smith will wave right into the allegations that Beata was administering these medications. Mr. Anderson says that was a definite problem. It says being administered by Beata. Mr. Shapiro says, I'll make a record of this. I think they put up records of Dr. Dees and Dr. Smith discussing medications and what to take child off of medications. Dr. Smith's testimony was, judge interrupts and says, it's just our court reporter is having a difficult time. Mr. Shapiro said, I was going to make the record of this. They put up text messages between Dr. Dees and Dr. Smith discussing what medications to take people on or off. Dr. Smith clearly testified in her response that she makes recommendations with that regard so she can evaluate how the child would do if taken off certain of their medications from a child abuse perspective. That's the purpose of the follow-up question. So they've alleged she had no right and no rule to be discussing with Dr. Dees what medications to taper and why she would want this question. Goes to the heart of that. They cannot block that question now if they don't like the response. Mr. Whitney says, okay, well, if you want it to be an instruction for a yes or no question, she can answer yes. That would avoid the 403 issue. Or we can strike Beata from that question. But as phrased and allowed to expound, it will go straight to everything the court's done to keep out. Mr. Anderson says, I'm going to object to number 3. No objection to 2 or 1. Mr. Shapiro says, with regards to number 3, Your Honor, they specifically asked, and that's been asked regarding Munchausen, they continue to open the door. They specifically asked Dr. Smith, did you think the allergies? Judge says, I'm sorry, let me just deal with what we're calling as number 2. And I just want to make sure when we say number 2 is when you told Dr. Dees to get Maya off as many meds as possible. Did you know that that was already in progress prior to telling Dr. Dees to do so? And defense has no objection.
That's a good question.
And Mr. Anderson says no objection. Judge says there's no objection to 1 or 2. And then says the judge, let me reread this third one. Mr. Shapiro, do you want to tell me your position on this? Shapiro says, yes, the plaintiff again continues to raise the issue that there was no basis to suspect Munchausen. I won't go back into all the instances they did in opening and with Dr. Newberger, but they directly asked this witness a question. Doctor, did you recommendations of something, dog allergies, have anything to do with Munchausen? They continue to use this as a sword to say that we need Dr. Sally Smith or neither Dr. Sally Smith or the doctors all children had any basis for the suspicion of Munchausen. They've done it throughout their entire case. And every time there's a question, the defense counsel or now this jury asking what basis was for her to suspect Munchausen, they throw up a massive shield and say, no one can talk about it.
Let me tell you real quick. They had a basis to suspect Munchausen. They had a basis to suspect it. I think they had a basis to suspect it. I think the evidence is kind of clear in that regard that they had a basis to suspect that this was something other than CRPS. And I think that when you see the emails from Beata to Beata, I think they had a basis to suspect it. But I am at the point where in this particular trial, they might have had a basis to suspect it. But did they have the ability to do the other stuff that they did just because they suspected it? Like if you present a child to me, and from what we've seen, the doctors in the ER are sitting here being presented with ketamine levels that they have not previously seen, and they're going, "That's a lot of ketamine." They have a basis to suspect it, but it's what they do. It's what they do after that. That's the problem. People are like, what other stuff? Putting her in a room, not for purposes of treatment, but for purposes of confirming and aiding the investigation prior to the authority to do that. That's one thing. Holding her down without an order that says that they can hold her down and take photographs of her. I get it. I get it. I know why the doctors were uncomfortable. I have no blame for the doctors being uncomfortable. But you don't have authority to do some of the things you're doing here.
They continue to pound this door open of allege that all children's is negligent for this diagnosis, or allege that all children's is, especially their opening statement, they said directly that because of this accusation, Beata lost the maternal instinct to protect herself. And now they tried to block the Munchausen's expert, who's going to have one chance to testify from this jury, to tell this jury why she had these suspicions. I absolutely respect this court trying to walk the line, but the plaintiffs keep jumping over it. Mr. Whitney says, Your Honor, we had this discussion on Monday morning. The defense counsel just alleged we're seeking damages for Munchausen by proxy. We specifically discussed this on Monday, and that's the reason why there's no discussion with this witness of Munchausen. These 5 binders of information she has, or anything in the report, this very reason. The judge says, well, here's my view on this question. Textually is asking about her investigation. I hear what Mr. Shapiro is saying, but I don't see how talking about dog dander or allergies constitutes medications or outside treatments. And so I don't think this question is going to that discussion that Mr. Anderson had with Dr. Sally Smith. I feel this particular question, since it goes to the scope of her investigation and what she was doing in the investigation, is outside the bounds of what we're going to allow. So I will I'm going to sustain the plaintiff's objection, and I will not ask that question. Red number 5. How about this one? In Pinellas County, in all trial protect cases, what percentage of cases do they take the children? What percentage were you involved in? Do you still have medical privileges at Johns Hopkins All Children's Hospital? Shapiro says, only. I know what the court's reaction is going to be to number 1 or 2, but I will say that frightens me that someone might have done outside research. Anderson says, we've got at least one nurse that would know.
Why?
And that would know this without doing any research. We have no objection to number 3.
I didn't get that question. I didn't get that suspicion because I've been following this trial. And I haven't watched the documentary at all. But I can get to that question. I can understand that. So I get that there's a concern that, well, I can understand how that question came up. And then I wanted to pull this up while I'm paused. Terry 54, holding her down. You haven't heard today's testimony, have you? I have listened every single day of this trial. Believe it or not, I have listened to every minute of testimony, argument, motions, arguments. I have listened to every minute, oftentimes twice. I know that the nurse testified today that she wasn't holding her down. I also saw the photograph, which I think contradicts her testimony, where the arms are being kind of held apart. And Maya, who the witness says, oh no, she wasn't crying, but you see the picture in her face. I don't think those two scenarios exist and they coincide. Now, I do believe that there were 2 sets of photos taken. I think Anderson tried to pull a quick one with that witness. I don't think there were 1 set of photos. I don't think it was multiple changes in that one instance. I think there were 2 sets of photos. I think there were 2 sets of hands and 2 people in the 2 different sets. I'm there. I get that part. But you can't tell me that child is happy and volunteering to be photographed in that instance when you can see the bottom half of her face and you know damn well she's crying. Don't tell me, what is it? Don't spit on me and tell me it's raining. Those were inconsistent. Now the nurse I thought she was credible in her testimony. I thought she honestly didn't remember half of these things. And didn't particularly care being on the stand and being asked about things that were several years ago. I thought she was fine. I think she does probably an amazing job with all of her patients. But I thought that was a little inconsistent. So people that accuse me of not watching the testimony, oh, I watch it. I watched every minute. And I've read the motions and seen the stuff outside of court. So they're holding hands. Okay. I'm not saying the case is worth 220 million, guys. I'm not. People think I'm not. I'm saying the hospital has a lot of things that they haven't been able to get around. I don't know what the jury is going to say or what they're going to do.
And number 1 and 2, I think my colleague nailed it. Those questions are frightening, says Mr. Hunter. Shapiro says, there's an objection. I think the plaintiff's wrong. Mr. Anderson says, I have no objection. 1 and 2 appear to go to her backgrounds. Maybe it's because I asked so many times how she testified in court. Shapiro says, we do object to 1 and 2. And again, I know this court's done an excellent job trying to screen for pretrial publicity, but I put on the record that that was the theme of the Netflix movie. So it is alarming to the defense that is coming from jurors. For this purpose of this question, we object to number 1 as well. Judge says, well, to be fair, I have seen so many newspaper articles and commentary years ago about this particular issue. I don't think this is a sole and exclusive Netflix issue. I'm pretty confident this juror didn't even see the Netflix. So what I'm saying is that concept is not Netflix or into that as a sole basis. And I also can see it is a fair implication from Mr. Anderson's question, but whether it's a fair implication or not, I'm going to sustain the objection as to 1 and 2. So we will only ask question number 3, which is, do you still have privileges? Red number 6.
All right, that was the dialogue I wanted to get. So Scott, I'm going to pull you off the stream. Thank you, Scott. Thank you, Scott. Thank you, Recovery Addict. Go check him out. He does the coverage all day long. So please go check out his live feed when he does that. It's been remarkably informative. He has a very nice and friendly chat. The voice sounds like butter, so not going to complain about that because I think that can talk me to sleep any day of the week. Let's go to actually Sally Smith answering the jury questions. And then after we finish with Sally Smith's jury questions, we're going to take a swoop and we'll do super chats before we get to the proffer. Before we get to the proffer. You know what? I might not do the proffer. I might hold on to that for Saturday. I think I'm going to hold on to that for Saturday. Yep. I'm going to do the proffer Saturday. Because 1, I have to wake up early for court. 2, that's going to piss me off. 3, I've watched that twice today already, and I can't watch it a third time. God, you guys really want the proffer? Yeah, okay, fine. It's not that long. It's pretty quick. Okay? So I'm gonna put a poll up in the chat. I'm gonna pull super chats while the chat is answering. And people have been asking about. Oh wow, okay. So this is kind of cool. People have been asking about the subscriber count because we're on the way to 200,000. Let me see if I can't share the window. Come on. You can do it. Why are you not doing the thing I need you to do? Because you're a computer and you misbehave, because you always misbehave, because you're my computer and my computer doesn't know how to behave. My computer can't act right ever. And I mostly, when I'm talking about that and I'm talking like that, it's mostly just buying time installing. So 1-99979. Well, should I just leave this up while we talk for a minute? Sally Smith. when I said that she presented well in front of the jury, I meant that from a standpoint of an attorney that asks of a witness to present not like an alien, like present to the jury not like someone that's aggressive and upset and frustrated and angry. Present to the jury like a normal human. She does a really good job. In that regard. Now, the statements are remarkably inconsistent for the deposition. And that problem I have a problem with. So I wonder how many people in the jury remember that. Oh wow. Who's the last one? So that's a big thank you, guys. That's a big thank you, guys. Thank you. Thank you for that. 200,000 subscribers. So that's really cool. You guys are really, really awesome. You guys are the best. Now I'm not going to do the proffer. I'm not going to be that. Oh no, you. Oh God. Oh man, you guys are killing me. If we do the here's the deal. I'll make you a deal. I'm gonna let the chat vote, and I'm gonna let you guys vote on it. Jury questions or proffer of Sally Smith. You get one choice. Jury questions, proffer. I can't do both. So while we're doing that, I'm going to catch up on super chats. So congratulations. Thank you, Amy. That's very, very much appreciated. It's remarkably kind of you. I saw this one come in a while back, and I'm sorry for not pulling it up earlier. KP, thank you for the remarkable generosity. I appreciate your remarks at the start of tonight's stream so much. You've been doing an amazing job with these recaps and overall coverage of this trial. I feel like this SC super chat minimally covers my cost of admission for the past 24 nights. Thank you for your hard work. KP, thank you very much. That is remarkably kind of you. It's been a very long trial, and 24 days, it feels like it's been 2 months, but we're here. Caitlin, Rob, thank you. So Rob, behind on today's stream, but want to say how much I appreciate your recaps. Your very excusable absence reminded me how valuable your commentary is. Let's not take advantage of that. Thank you, Caitlin. Mara. Hi, Rob. Wouldn't this difference between demeanor in depo versus live come across as an act? It can. I don't know that she knows her depo was played. She was so different in depos. How can this feel genuine? I don't know that she knows her depo was played. She shouldn't know her depo was played. I don't know. Ron, if Sally Smith has been depo scarred, do you think the jury can be too, listening to her depo and therefore today's testimony doesn't move the needle? It's possible. That's why the plaintiffs played the depo. Melanie Hideki, thank you. Is it possible she was called for the sole purpose of getting that proffer for appeal? No, they could have done that outside the presence of the jury. They would not have had to put her on in front of the jury for that. Creed M, thank you. Yeah, depos are multi-hour waterboarding sessions with lawyers. Everyone is different in depos. Even Maya lost it in a depo. Lawyers are unhinged when there's no jury to worry about. That's correct. That is correct. I think I made that comment during some of the depos, and especially in this one in particular, how when you're in depos, you get agitated, you get frustrated. It's still a thing that the plaintiffs or defendants can put on. Peter Randolph, Rob, could the jury ask to rewatch her deposition when deliberating? No, they have to remember the testimony. That's what they get. They get the testimony they hear live, and the deposition testimony they get to hear. That's what they have to recall. They have their notepads, and these jurors are taking so many freaking notes. So many freaking notes. Melanie, thank you. Wasn't DCF called twice? The first DCF said no. Second, no, it was 3 times. First, no. Second, no. Third, and then they got it on the third. And Sally Smith looked at the records. Yes, in all instances. For the kids, Rob, explain to me how child abuse investigation goes on for 3 months. How much time did she need? Should that damn slow to make a determination? No, for the kids, it's not that the investigation goes on for that long. It wasn't about her investigation. It was about how to treat Maya, when these DCF investigations begin and when a shelter order is entered, a plan is put in place by the court. The court puts a plan in that says, this is how we're going to go about reunification. One of the terms of that plan was to eliminate Maya's use of ketamine or to remove her from certain medications. And when you comply with stage of that plan, you get further in reunification. So the process of the shelter order wasn't so much so the investigation could go forward. It was so that the court could supervise altering Maya's treatment, altering how this family dynamic worked to take the child that was presumed to be in a situation of child abuse and put them back into a household that was stable. That's what the plan is intended for. Rambling Southerner, thank you. Licensed clinician here. You aren't allowed a patient's chart that you aren't involved in the treatment of. It's a HIPAA violation. Need to know only people lose their jobs for this. They do. I know that. It's pretty wild. OB nurse Chelsea, my lawyer told me if I can speak to a routine I have that I do with every patient that holds weight. It does, because it's the way I do it every time. I always foam in. I always set up IV the same way, etc. Yes, but when the call of the question is, how did you introduce yourself to this person on this day? I don't think your answer would be, I do this every time. It would be, I did it this way. And if the lawyer asked the follow up and said, how do you know? Then you can say, I have done it that way every day for the past 20 years. That's how you go about that. KBF, thank you. Her statement that she got involved before the call and her order that they couldn't take Maya from the hospital means she was acting beyond the scope of her authority as CAP. Jay Hatch is at fault. That's your opinion. You're allowed to have it. JPC, could either Anderson or the jury ask her if her attorney had been communicating with the defense attorneys? No, I don't. I mean, they try to get into that a little bit, but I don't know. I think that would be objectionable, argumentative. San DB, Rob, is it illegal for SS to just look up medical records without court order subpoenas, even if she's investigating child abuse? I'm not a doctor. I don't know the specific ins and outs of HIPAA. I did review the statute that was being cited by her, and I don't know that that applies. I don't think that she had the authority to look at that. I think that is a question, and I think that her answer to that was not persuasive to me at all. Allie Jean, she only spoke with her lawyer, but could the lawyer be a go-between between defense and get around this potential question issue? It's possible. I don't know. Casey Cat, thank you. Sally Smith lies about access to medical records. You may only access them, 1, if you are treating doctor. 2, you have a patient parent sign the release. 3, you have a court order. Every access leaves an electronic signature. They have those access records. They have presented them. They are in evidence. Lita Randolph, thank you. Rob, I was an ass when I said you took too long to answer super chat questions. No, you weren't. You really weren't. I do my best. I fall short of that, and I can always do better. Now with 5K live watchers, we're 6,000 now. Hit the like button, please. And if you wouldn't mind subscribing, please do. And 200,000 subs, I apologize for my impatience. There's no need to apologize. I want you here. I want you watching. I want to make sure I'm giving back to you guys. That's part of this process. Gingy Probs, I worked Fed labor and employment law. RE Defense's inability to locate CB's annual review because they didn't do them. If anyone was terminated, this is Kathy Beatty's review. That's for a different day. We have discovery issues today. Like the review just went missing. It just wasn't there. And then it wasn't produced. It's a big issue. I'll try to explain that on a different day because they're going to bring the other doctor back up. Maybe that's when I'll do it. Not the other doctor, the other expert back up. I'll explain it then. If anyone was terminated due to poor performance during that same period, they will have grounds to contest it. I agree. The fact that there was no record of that was a problem. Canonical Heat, come on, 200K, and I'll give 50 memberships, and that isn't a pledge. I'll actually do it. Canonical Heat, you don't have to do anything. Thank you. You've done so much already. Janelle Bell, following you since Debt V Heard and love your recaps. Just realized you're near my daughter, a freshman at George Mason. We visited from Florida last year and fell in love with Fairfax. Thanks for your Maya coverage. Fairfax is amazing, Janelle. It's amazing. I love Fairfax. Professor of Logic. If Rob hits 200,000, everyone gets a copy of the swimsuit calendar I produced. Unfortunately, the agency failed, so I had to do 11 of the months. Mary Coppola, did you say plaintiffs had a gaping? Oh, nope. They have there's an issue with their case. I think that's the issue, the causation issue in the suicide. Whiskey Sour, Rob, I took your advice and started Springfield Armory M1A restoration project. Really cool. Good. Go make something. That's awesome. Courtney Michelle, there's so much hate and selfishness in the world today, but you are so incredibly compassionate. We need more people like you in the world. I just want more people to think a little bit more before the words exit their mouth. I do it all the time. I make mistakes. I say stupid things. We all do. It's just recognizing that we make those mistakes. You help restore a little bit of my faith in humanity. Thank you. It's very sweet of you, Courtney. KBF, it's always hard when your client makes what might be a bad decision from your point of view, but yes, it is their life, their family, and they make the call. My job then is to be supportive and get them that. I tend to agree, unless you overcross a bound that is recognized in the law. That's the question. Tilly M. Lopes. Lopes or Lopez? Either way, Lopes. Another day, another appointment, no diagnosis still, and completely dismissed by the doctor. I want justice for pain patients. A lot of people are this trial is impacting a lot of people. Nancy Jomo, your coverage and personal relatability is unparalleled on coverage of this trial. I appreciate and thank you for being you. Nancy Jomo, thank you very much for that. Thank you. Outside the box, grab your comfort unicorn for Sally Smith's proffer. Recovery addict read the Hippocratic Oath afterwards. It brought me to tears. Motion for the judge, Unicorn Carroll, to preside over your robot jury. Appreciate you, Rob. Judge Carroll is presiding over the robot jury. The robot jury is here. Automata. So given the proffer cross today, any chance that Anderson spending time elsewhere is a tactical move because of being hamstrung by court restrictions on Sally Smith and Kathy? Though at this rate, they won't even have a rebuttal case. They are close on time. They're going to run to the wire. They will. Canonical Heat's never too early to hug a mod for all they do, and hit the like and subscribe. Come on, so close to 200K. We're there, Canonical Heat. Yes, the mods have been absolutely remarkable. Absolutely remarkable. I have asked so much of them. I have streamed every night, and this is not easy. So thank you to the mods for all that they do. All that they do. It's been remarkably, remarkably appreciated. Yes, Peter, we hit 200K. Thank you, my friend. Very much appreciated. Thank you, sir. Oh, God, look at this. Runkle the Bailey. Thank you, Ian. It wasn't that long ago that I wrote that 200K sign on the door when you came back from Debt V Heard. It was fun. Oh, God. Sandy, Sandy, you are moderating. You are donating time, all the time and effort. Thank you, Sandy. Congratulations, Rob. We couldn't be happier for you and proud to be a part of your channel, team, Law and Lumber. Thank you. Thank you, guys. All right. Why don't we check that? Ryan Matt, why I say I want to get Rob certified emotional support litigator. I want to get Rob certified as an emotional support litigator. I can do that. Emotional support litigation? Sure. Kurt, thank you, sir. Rob's okay, I guess, if you like that sort of thing. Oh, God, you guys are great. You guys are amazing. Thank you. Thank you. Thank you. Thank you. So cool. So cool. Calypso and Vixen, absolutely amazing. Congrats, Rob. No, I really need you to the proffer. Please, please, please. I had to put myself in timeout on Recovery Addict stream for this. LOL. Well, you'd put yourself in timeout, Calypso. That's you're a mod on that stream. You're a mod there. Oh, God, all you guys. I can't. The chat right now, I'm trying to keep up. I'm trying to keep up with it. I can't. It's too fast. It's too fast even for me. No nonsense. What is that? No nonsense. Yeah, no nonsense. No nonsense 1216. Thank you for the very generous super chat. See, my brain isn't functioning right now, guys. Okay. So I got to get to this. I got to get to this. Come on, Rob. Let's see. What's the poll at? Oh, God, guys. 1,900 votes in, and it's holy smokes, it's neck and neck. You know what? We're gonna do both jury and Proffer, and then we're gonna. I was gonna do Dr. Mal. I'll talk about him tomorrow, and the jury instructions. I'll talk about those tomorrow. I'm gonna find the actual written instructions. Those instructions are really, really, really important. The chat was divided 51%, 49%. Yes, you can yes, you can do an ambush.
I sent a super chat, but I was like, I got to get in on this. This is amazing. Congratulations.
Thank you, sir. Thank you for my sign. I got my sign.
Little throwback there. I was like, crowd, where's the Sharpie? Where's the Sharpie?
For those of you who don't know, when Ian hit 200,000 subscribers when he was staying with me, staying at my house, doing the Depth Heard coverage. He was at court when he hit 200,000 subscribers. On his way back from court, I had beaten him home from my job, the lawyer job, and had pulled out a bunch of pieces of paper, taped them together, and wrote "Congrats on 200,000" and put them on the front door, so that when he walked up the steps to the house, it had 200. Congrats on 200,000. So that is the purpose of the paper sign.
That is a what is it? What do you call it? A callback. But yes, I was like, I got to do it.
Okay, so Ian, would you like to stick around for 2 spicy segments, or you can jump off?
I will stick around for a little bit here. I am out of the loop, but I will try not to derail too badly.
We are now at the point of jury questions. Now, I have told the chat the subject matter is sensitive, so we don't go too much into joking or laughing about a lot of this stuff, but some of this stuff just gets a little bit wild. So
Always
we
does.
have a jury bumper. Have you seen the jury bumper yet?
I have not.
The court has said our favorite thing: bring the jury, bring the jury, bring the jury.
That's the jury. So the jury has dubbed themselves this jury. So they now refer to themselves in the third person. This jury. Are you telling this jury in their questions? And
They might have been directed to do that.
oh no. It started, it transitioned. They first started saying, are you telling us, or this random stuff? And then all of a sudden there was a couple of witnesses where it was like, are you telling this jury? And it was after Mr. Shapiro, who's the defense counsel, kept on referring and using that question, not the what if any question I hate. It's the other one. Are you telling this jury? I hate that question.
Oh, that might be that they're making fun of defense counsel, and that should really get them to start thinking about, I don't know, how many zeros they have to write? Because
there's at least one. There's at least one on the jury who's very aggressive anti-hospital, but there's some on the jury that are they're all asking really, really good questions. Really good questions. So Sally Smith testified, and well, her testimony was very different than the depo that I played you last time. The demeanor was very polished. She's not supposed to know that her deposition was played because there's a rule of sequestration. So this is the jury's questions of Dr. Sally Smith. Let's see. Come on, Judge, bring us back. 307-24. 307-22.
Okay, please be seated, members of the jury. I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? Correct. That you haven't seen any media reports of this case. Is that correct? Correct. No one approached you. Is that correct? Outside of Dr. Smith's presence, I went through the jury's questions. I'm going to be able to ask a good number of them, but not all of them. Dr.
1.5.
Smith, have you had a conversation with a nurse, Bonnie Rice, from Tampa General Hospital in connection with Maya Kowalski?
She's a nurse practitioner, but yeah,
When approximately was that conversation?
I'm pretty sure it was in late October, early November of 2016.
Have you had any conversations with Nurse Practitioner Rice in calendar year 2015 with respect to Maya Kowalski?
No.
Next question. Do you know why it is the hospital's policy to contact you first instead of reporting suspected abuse to the child abuse hotline?
It's an unusual situation, and because of the way that the whole system is set up in Florida, and they have to report for me to do a medical evaluation, sometimes they're not sure what to do. And so in those occasional situations, I'm going to say once or twice a year, a doctor from All Children's would call me to ask me a question about the case that they were involved in, and my expertise related to the child abuse and neglect question that they had.
Correct me if I am wrong. There is no harm in contacting the hotline prior to contacting an expert first.
I'm sorry, can you,
Can you repeat that question that I don't want to answer because it's very, very, very aggressive?
Yeah, the jury can get away with asking questions that maybe the lawyers would object to.
They
From the other
do, and
lawyers.
so the cool thing is they do sidebars. So the jury says, "Here's all of our questions." They write down all the questions. The judge then goes and marks them read, READ. So like as in he's read them all. So read jury or question number 1 and marks them all, and then they have debates sidebar about which ones they're going to allow to be read in open court. So
Oh, cool.
they get to assert their objections, relevance, hearsay, etc. But a lot of them are. The jury has picked up on questions that the attorneys have dodged.
If I am wrong,
Juries
there is
often
no harm
hate
in
objections.
contacting the
Yeah.
hotline prior to contacting an expert first.
the only situation would be if there potentially wasn't really enough evidence or whatever to justify a report. So otherwise, no, I mean, typically the report gets made before I, as an expert, would be involved, almost all the time.
How would CPT normally access the medical records?
So I always would access them through my remote access.
Did you get the caveat? The allegation and what she testified to is that she got a phone call from the treating physician that said, "Hey, check this out." It was before the call to DCF. She then goes and accesses the medical records via her staff privileges and then calls back and says, "Here's blah, blah, blah." Then several days later, you get a call to DCF, and DCF then finally gets authorization to basically initiate a removal action. The question asked was, how does CPT, how does the child protection team usually access the medical records? Her answer
Is
was not
I
to
did.
that question.
Yeah. This is something experts get good at, is answering questions that are not the question that was asked. And lawyers would follow up on that with a follow-up to be like, no, that wasn't what I asked.
Yep.
But the jury
Report
can't
gets made
really
before.
in real time.
I, as an expert, would be involved almost all the time.
How would CPT normally access the medical records?
So I always would access them through my remote access that's granted as a member of the active medical staff. If it was a child protection team, say from Sarasota County, that the person didn't have privileges at All Children's, then what they would have to do would be to, submit a request for the records to the hospital to obtain those records.
You mean you were able to get them
Does the
beforehand
county
via hospital?
child protection team have access to medical records normally without privileges?
Only because, well, not like I do with it's an electronic access. Another team or somebody besides me would have to make that request. And there's statutory language that requires the hospital to provide those records in the furtherance of the investigation, so they can get them, but they can't just log in and see them as easily as I can.
Are the physicians that are part of the child protection team required to have privileges at a hospital to provide a medical assessment?
I'm pretty sure that is correct. So mine's easy because they're just the one hospital. Other teams, like say, for example, in Miami, I think the medical director probably has to have privileges at Jackson Memorial and Miami Children's in order to go in and see the child. But I'm honestly not sure because it's not my situation. So I don't know. Part of our credentialing, we get re-credentialed every 2 years. We have to do like certain, HIPAA training about medical records. There are rules about which ones you can and can't access. And it's pretty closely watched and monitored. And so, I can do that in my role as the medical director of the child protection team. And on these occasional situations where they call me separately because they're not sure what to do and need child abuse pediatrician expertise, I can do it in that role as a member of the medical staff.
Is it standard for a child protection team physician?
That part. I can do it in that role as a member of the medical staff. You mean not as the medical director of the child protection team, but in another capacity?
And that's
Like-
the way you get yourself into a lot of trouble with privilege stuff, like where you start using one power to affect another.
The
Like-
chat was the several people have kind of, one of the concerns I have is there's a lot of ends justify the means just because there is abuse. And you're a criminal defense attorney, so you're a good one to talk to about this. I use the example of, let's say a cop is walking down the street and gets a phone call from his buddy that says there's drugs in this house. And the cop says, I'm going to go into this house. The cop opens the door, goes inside, finds the drugs, calls the buddy back and says, yep, there's drugs. Next day, cop gets a phone call from the magistrate, and the magistrate says, Mr. Officer, here's your warrant. Go in and seize the drugs.
We're going to have problems.
Yes. Can't do that.
Or at least I'm not going to have problems. The cop is going to have problems. I'm going to have a great day.
You can't do that. And she's open. She's testifying so casually to this.
And I mean, we had an officer who got into trouble doing things like using the police databases to check things out for his friends.
Oh yeah, that's another one.
And we've seen things where, for instance, let's say a concert is wanting to have they want to have security. And so they might hire off-duty police officers. And in some places, there's actually a program that allows them to approach the police to get them to hire those off-duty police officers in that role. All of that's legit. The problem is let's say they get a person there and they're like, I'm going to run their name through my police credentials on behalf of the concert venue.
Mm-hmm.
Now they've crossed those permissions, like those separate silos, and now they're into the land of they have committed wrongdoing. Because, they're entitled to be security for that, but they're not entitled to use their full police access.
Oh, so here's the thing. Creed M asked the
Treading into
question.
that.
Creed M asked the question. Can you sue the cop for that, though? Yes. Yes. You can.
Would that, in the U.S., would that be something that would be covered under
1983 claim.
Okay.
Deprivation of personal rights. Yeah. Acting with a state actor. Yeah. Yep. You can.
Because I know they have immunity for so many things there.
Yep. Qualified immunity, but qualified immunity only works when you're acting within the capacity and confines of what your job permits.
Yeah. And if you're stepping outside of it, you're into a world of crap.
Yep.
To offer recommendation to a child's treating physician in a suspected child abuse case.
With regards to potentially certain tests or certain needs of the court, yeah. So for example, if I'm seeing a child that has a bunch of injuries and they need a follow-up brain scan, I can make that recommendation to the team. Could you please do a brain scan on such and such date? And, typically they're going to do what I ask them to do in terms of that, because it's something I need for the purposes of the investigation and to assist all the various people involved to make a good decision in the case. So I think that answers probably.
Who made the referral to your child protection team for the evaluation?
The child protective investigator called our person called a case coordinator that was on call, or was the designated person to receive what they call intakes. So when there's an investigation that's been initiated, particularly in a case like this where there's a major medical component, then the child protective investigator calls the child protection team, and one of these case coordinators, or we actually had a person that they called an intake coordinator, takes the information, kind of reviews everything, and then that person would contact me and say, Dr. Smith, we need you to go down and see such and such child at the hospital.
When you told Dr. Dees to get Maya off as many meds as possible, did you
Wait,
know
Dr.
that was already
Dees?
in progress prior to telling Dr. Dees to do so?
I did not.
I kind of want to say it.
Nope.
Do you still have medical privileges
Okay, in the
at Johns
chat for saying
Hopkins
it.
Children's Hospital?
Yes, I still have active medical staff privileges there.
Members of the jury, that is all the questions that I'm going to be able to ask. So, Mr. Hunter, you now have the floor, sir.
All right, we're gonna fast forward to the proffer.
Chad already
So-
knows where I'm going.
No, because I've actually, so one of the rules I've had with this entire trial coverage is that we're not doing, and for the chat too, this is not FNF. This ain't FNF. We can save that for Friday Night Frenzy or some other stream, but in the context of the Take Care of My trial, we've been really careful about making sure that we're being respectful of everybody, all the witnesses, all the parties. There are times and places where we can do that, and right now with house, because we're talking about a child that was removed from the care of her parents.
That's fair.
And a mother that committed suicide as a result of that. So this is one of those cases where
It's a little sensitive.
just a bit. So we are now outside the presence of the jury. There is no jury, and I will swoop to let you know there is no jury. There is no jury present. No jury. There needs to be a proffer because this is going to be appealed by both parties. Period. End of story. Both parties are going to appeal. And they wanted to go into Chapter 39 issues. They wanted to go in the investigation. They both do. Mr. Hunter does because he wants the immunity. He wants the immunity because the hospital wants the immunity for all the actions that are done. Mr. Anderson does because he wants to attack it. So they both have an axe to grind in this proffer. So that little that pleasant demeanor that we saw from Dr. Sally Smith is gone. It is no more. That pleasant demeanor, the jury is out of the room. What is a proffer? A proffer is an offer of proof. Literally proffer, offer of proof, proffer, where you are saying, Judge, had you allowed me to explore this avenue, had you allowed me to explore these questions with this witness in front of the jury, this would have been the testimony I would have elicited.
Yeah.
So that when
so this is just for appeal records, basically.
Yes,
just
it's
so
for
that,
appeal. Because
Yeah.
what happens is if you appeal and you don't do this, then the appellate court says, well, we never would have known that you would have gotten there. We never would have known that. So we can't grant your appeal. You have to give the appellate court an understanding of what you would have gotten, what you could have done. We are now in the dear appellate court. This is what I would have had them testify to. Oh, all right. Everyone buckle
and I mean,
up.
it's a good system.
This just buckle up. We are, and this is kind of a comment to the chat, and this is for my mods. Like this, when I admonish the chat, it's not because I don't want you guys commenting. It's because my mods, there's like 5 of them, and they can only catch that. The chat's flying. So I'm asking you to be kind, please, for the sake of my poor mods that are just overworked.
I'm going to ask that you be back at 1:45, so just a couple extra minutes beyond our normal lunch time. Do not discuss this case amongst yourselves. Do not do the investigation and receive no information. See you at 1:45.
All rise. Next case.
The jury's out of our presence. Dr. Smith, there's a couple things we needed to do before we were able to break for lunch. So, Mr. Hunter, you have the floor.
Thank you, Your Honor. Sir, I'm just some clean copies of the report here.
We're doing a proffer, just so you understand.
Okay.
Oh, Madam Court Reporter, if you could mark this transcript as the proffer.
Thank you, Your Honor. Dr. Smith, this is a proffer for a potential appellate record. And what I'm going to do is ask you some kind of conclusory questions and some summary questions to avoid you're having to sit here for a long afternoon and all of us the same way. In the process of your investigation of the Maya Kowalski case, after it was referred to you, did you conduct an investigation? Did you gather some medical records?
I did a medical evaluation, including gathering a lot of medical records. Yes.
Okay. And did you, in fact, promulgate two different reports
Yes.
regarding that? One was a preliminary report in October of 2016.
October 13th. Correct.
Okay. And the other was one signed December 2nd, 2016.
Correct.
Do those reports both indicate the results of your investigation and review to that date?
Yes.
Okay. And in connection with your report in your investigation, did you obtain certain medical records regarding Maya Kowalski?
Yes.
And does your report, does the report you signed December 2nd, 2016, fairly and accurately reflect the records that you gathered and then reviewed for your report?
Up until that time, yes.
Okay. And then were there subsequent records you reviewed after that, after you received after that date?
Yes.
And does your report first of October, I think you said 13th, 2016?
Yes.
Does it fairly and accurately reflect your conclusions up to that date?
Yes.
Okay. And that would, if we were to walk through that report and what it was based upon, would your indication be that it contained and fairly reflected the outcome and your conclusions of your investigation up to October 13th, 2016?
Yes.
And would it also reflect?
Did you see the demeanor change, by the way, already?
Sorry, repeat.
Like, have you seen her demeanor change already?
Oh, her demeanor has not been thrilling me the whole time.
Well, she went back to very direct answers, and
What you advise up to the conclusions
Experts
and
always do
facts
this.
of which you advised the court, the dependency court, as of that date.
Yes.
Okay. And I'm going to show you what we're going to mark as whatever the court clerk tells me we're going to mark it as.
What's the next in the series for the defendants?
3328.
For ID.
For ID, it's not coming into evidence.
Correct. This is 3328 for identification. Let me just ask you, is that a true and correct copy of your report of October 13th, 2016?
KBL, I do.
Yes.
Sorry, I wasn't
Finish
pulling
this
it
up, Mr. Hunter.
KBL, I
It's
do.
two-sided, so just be careful.
I do.
And then after you rendered that report of 2006, these are new lips, I'm sorry, October 13th, 2016, after you rendered that report, did you continue an investigation as reflected in the report that you signed on December 2nd, 2016?
I continued my medical evaluation up to that point in December and gathered lots of additional records beyond what I had on October 13th. Yes.
Okay. And I have a badly marked up copy of what I'm going to ask be marked for identification as defense exhibit.
Well, is there already a specific exhibit number on that? Down at the bottom, Mr. Hunter, first page, look at the first page.
December or the October?
December.
The December is 3045. 146.
The answer to your question, my copy doesn't, but I trust Mr.
Mr. Hughes, will you say that to let the clerk know what defense numbers are the two reports that have been previously marked?
So the first report is in October 13, 2016 preliminary report. It is defense exhibit number 3044. The
For ID, it's not in, it's just ID.
Just that for identification purposes. For identification purposes, Sally Smith's December 5th, 2016 report is Defense Exhibits number 3045, and that's pages 1 through 46, and it's currently being printed.
Or can't we just put the first
That's,
page
that's
up
fine.
if you
That's-
want?
That's fine. Okay, I apologize for that.
Thank you, Mr. Hughes.
And to the clerk for attempting to gum up the works one more time. Does your December 2nd, 2016 report, Defense Exhibit 3045, does it also reflect your opinions and conclusions as of that date regarding your investigation?
Regarding my medical evaluation, yes.
Okay. And just if you would briefly tell the court what your opinions were regarding this matter as reflected in that report.
As reflected in that report, it was my conclusion that there was what we call positive findings for medical child abuse, and that the medical record review and the history taking and that kind of thing that I had reviewed provided very strong evidence to support that conclusion.
Okay. Was there any conclusion, and is that the conclusion of medical child abuse would colloquially be known as Munchausen by proxy?
Yes, and I believe it's even in the what we call the impression. That was my conclusion in the report. I put in parentheses Munchausen syndrome by proxy because that's kind of a well-known term for this situation.
Okay. And did you reach any conclusion regarding conversion disorder?
Do you notice that she didn't say diagnosis?
Conclusion, not
Yes.
diagnosis.
And what was that?
It was my opinion based on all of the observations of the various medical staff and team and staff members, et cetera, as well as based on multiple other physicians' reports that I had reviewed that she had a conversion disorder. It's actually called a functional neurological disorder now, but at that time it was called a conversion disorder.
When you say she, you refer to Maya Kowalski?
Maya Kowalski, yes.
In reaching the conclusions and opinions you just expressed to us, how many pages of medical records did you review?
I don't know exactly as I sit here, but well over 2,000.
Okay. And I see you brought with you today a stack of 3, 4, and 5-inch binders that is on the table in front of you. Are those at least some of the records you reviewed?
Those are all of the medical records that I printed. So there are some that I reviewed in the electronic medical record from Johns Hopkins All Children's Hospital that I don't have copies of. But everything that I had a copy of in terms of all her medical records going back to actually her, first visit to the pediatrician up in Chicago is in those binders.
Okay. And did the material you reviewed also include certain online WordPress blogs that had been created by Maya Kowalski?
Yes.
I believe that's all I have, Your Honor.
Mr. Anderson, do you have anything in proffer?
Oh, he does.
Before, or let's say,
During depositions, attorneys have different styles when they're deposed. So Sally Smith has been deposed 5 times. She came to court with 6 binders. 5 times. I have referred to the comment I think I made before. I don't know if you've heard me say it, deposition scarring, where a witness takes the stand and they've been so burned in depots that they're like really reticent in what they're testifying to.
Oh, and it happens mid-trial too, where you can just like slam a witness and they're just like day 2, that witness comes back and it's like, yeah.
Yeah. So 5 depots that she's done, and attorneys have different styles in depots, and they don't want to be overly aggressive because I've told the chat that depots are the Wild West. There's no judge there. There's no judge there to call the balls and strikes. You're fighting with the other attorney. If you get too aggressive, the other attorney postures and says, "This depot is done," and they walk out and they do this dramatic stuff. Right. So that's how depositions work. So usually,
And then
attorneys
usually
in
sanctions
depots-
start happening. But yeah.
Well, yeah, but usually attorneys in depots, there's a bunch of posturing, but there's not really aggressive cross, right? You're gaining information, you're trying to button them down, but you don't have the same ability to do the thing that you can when you're in court. Fair?
Yep. I mean, sometimes I had a case recently where it was like we could do this by depo, but we did it in court instead, just so that we could have a judge to like manage objections, because otherwise it gets crazy.
Yeah. So this is the first time that she has been really crossed. And had
And
to
if
answer
you
the
look at her face,
questions.
she looks pretty cross.
Well, it doesn't get better from here.
Right at the start of this, in the first part of October, you had a call with Dr. Kirkpatrick, did you not?
I did.
And Dr. Kirkpatrick explained to you that he had been treating Maya Kowalski for CRPS, correct?
He did.
And he told you that statistically speaking, CRPS is often mistaken for conversion or Munchausen by proxy, did he not?
I don't really remember exactly what his words were. I took a few notes from the conversation that I had with him, and I know that there was some general discussion along those lines.
And yet you did not put anything in your report about Dr. Kirkpatrick, did you?
Yes, I believe there's a whole section about his medical records.
Yeah, except for the fact that you did not tell anyone in that report that he had warned you off of going after the Kowalskis.
It's completely irrelevant for a child protection team medical evaluation, because that's the whole point of the evaluation and gathering all the records. The problem in these cases is that the treating physicians have not done that. And so the fact that he, who sent her to Mexico for the ketamine coma, told me not to investigate child abuse, it was completely irrelevant to me, because my job was to investigate child abuse. So if I had come away from my job saying, I was supposed to do this, but this doctor told me not to, so I'm not doing it, and there's no evidence of anything here, I would not have been doing my job even remotely near a standard of care.
Okay, fair.
Do you not understand the importance of putting both sides of the story in your report?
Oh, shit.
This is one of those great questions that you just can't answer correctly. Yes, I understood. Then why didn't you do it? No, I didn't understand. Oh, then you're crap at your job.
If we could ask prosecutors this question, the job of the prosecutor, the job of the investigator, her job, oh my God, Sally Smith, I'm sorry. I didn't mean to do you dirty. There, wait, nope. There we go. That's better. Her job is to investigate and to put together all of the aspects of that investigation into a report and say whether something is or is not present, whether child abuse is or is not present. By nature, the fact that that report has to conclude whether there is or is not child support, the is not part of that means that you have to take into account information that might refute the existence of child abuse.
You gotta have all the evidence, not just half the story.
Both sides of the story is the responsibility of the various people who are going to present it to the court. My job as the medical director for the child protection team is to do what I need to do to assist the investigators and the detectives and the attorneys that are involved in the case as to whether there is evidence to support a diagnosis of whatever type of child abuse is being assessed.
Or evidence that refutes that, correct? Or evidence that refutes that, right? Because if you come across evidence that refutes that, shouldn't you include that evidence in your report? I'm not talking about whether in this particular case, any of what Dr. Kirkpatrick said or anything else would be given more weight than anything else, but the fact that it's not included, the fact that it's not given any weight whatsoever, it's that part. And the answer of, I'm sorry, but the idea of both sides presenting their case, that's for, that's for those other folks in court after the child has been removed from the care of the parents. Ma'am, you and I would have words, a lot of them.
She's just on a path to, like, let's take some kids away.
So it's not my responsibility to lay out some whole long argument about what it might be otherwise if I have extensive evidence to support that it's a type of child abuse.
Dr. Smith, you know there wasn't a single child psychologist or child psychiatrist that diagnosed what you were claiming. You're aware of that, right?
That's also irrelevant.
So
No, it
you
isn't, though.
are the ultimate decider of medical issues which you have minimal or no training in.
I have extensive training.
Yes, but
In-
you're not.
It's a proffer. You can answer.
Anderson is getting pissed. So lawyers usually are very composed in their questions. For example,
Oh, he's
when I'm
going
in
for her
spicy
neck.
territory of questioning, I am very composed. My version of cross-examination is never aggressive. It's casual. Anderson's getting pissed. She's getting pissed. They're getting snippy. This is just oh baby.
Dr. Smith.
I have extensive training in evaluating child abuse and neglect. Medical child abuse is a child abuse pediatric diagnosis. There is a parallel track in psychiatry where there's a thing called factitious disorder imposed on another, which
Okay.
is assessing the perpetrator or the caretaker in that scenario. But I don't need a psychiatric degree to assess medical child abuse. I'm very well trained to evaluate medical child abuse based on my child abuse pediatrics experience and board certification.
Well, there's not a single child psychologist or psychiatrist that agreed with you. You do realize that, don't you?
No, I don't.
Oh,
Well, being a child psychologist or psychiatrist that examined Maya Kowalski, who agrees with you?
Well, that wasn't their job to write in the report whether there's medical child abuse. So that specific thing documented by, for example, Dr.
oh,
Cabot or
she's doing so badly.
That is not an answer. That is not an answer. Matt Bond, who started covering, like, I started seeing Matt Bond's name pop up in chat during this Kowalski coverage. Matt Bond's from Australia. He suffers from CRPS, and I'm glad to see him here. Congrats on 200K. And this is the phrase he always uses, and it's my favorite. It's one of my new favorite phrases from people in the chat. My spiffy legal mumbo jumbo talky brother from another mother. So
Nice.
thank you, Matt, for being here. That's not an answer to the question, Dr. Sally Smith.
Dr. Katzenstein. I don't know. Honestly, I'd have to look back to see if they ever documented that as one of their diagnoses, but that's not their job. My job is to assess that. And if I present adequate evidence to the court can act on that. So, the court has every ability to.
So you're saying you're trying to reach a threshold, right? So you're saying you are aiming at a threshold. That is what you're.
My job is just to find evidence to say there's child abuse. And, who cares how many innocents are hurt? Just call me collateral damage.
take this out of this case for a second. And people in the chat are going, Maya Kowalski was different. This is different. Take it out of this case. Like, take this out of this case. Imagine this person is someone that has authority, administrative authority over you or your children in some capacity, whether it's in the school, whether it's an officer, whether it's a medical provider. Imagine someone has this level of authority, and the thought process they have in every interaction with you is that there's a threshold that they are trying to gather information to get.
I mean, I
Yes.
see it in criminal cases where, you've got a cop who's just decided somebody's guilty. And it's a great way for guilt or innocent people to get convicted, but also B, guilty people to get away with it. So
it is not for me. I have read Beata's emails to herself. I have read them. I have said that the presentation with the levels of ketamine, I have said the hospital had every reason to doubt CR. Well, they had every reason to question the diagnosis, every reason to think Munchausen by proxy. They had every reason they could have. They had that ability. What I am talking about with this particular individual is very different. It is about someone in a role that, I mean, she has no business being in this job. As someone who
sadly,
practices
she's
law
not the only
in
one
family
like that
courts,
either.
as someone who's practiced law in family courts on a regular basis, like I was there today, I'm there tomorrow at 9:30 a.m. That's a reminder to me to finish this up. She has no business. I do not want to read her reports. I don't want to see from her reports. I don't want any. When someone approaches the job in this capacity, where this is the goal, this is the end that they are trying to reach, and not a fair assessment of both sides. She is openly admitting, I don't care if people are accusing me of being biased here. I've watched the depots. I have seen this stuff.
And the other thing is that if you treated her under the same standards that she's treating other people, she would find it to be highly unfair. Like, let's say you just let's say the judge went through her testimony for every possible, and only considered evidence consistent with perjury and not any evidence consistent with anything else. Well, anybody
Yes,
under that lens, you would think that they committed perjury because
that's
you
a
just
good
see like
example,
every
Ian.
inconsistency.
That's a really good example.
So, well, thank you. I mean, ultimately, the goal should be the good of the child, and the good of the child means getting it right. Not just like taking the kid away from their parents in every circumstance where you could possibly string a story together. It's you got to get it right.
This is a fair take, KBL. I'm with you here. My problem about talking about this in this context of this case, though, the Kowalski are suing J Hatch for $220 million. And I can't separate that. That's fair. That's fair. I think some of the legal claims, I think some of the legal claims of, the causation issue with Beata Kowalski and her suicide, intentional infliction of emotional distress on that's tough. I understand that, but I can't disconnect the method part. I have told people in the chat repeatedly that for me, this is not a med mal case. It's styled as a med mal case, a medical malpractice case. To me, this is an authority case.
Yeah.
And is it 220? No, I don't know.
Always
I
ask for
wouldn't.
more than you're going to get.
Yeah.
In fact, you'll hear civil litigators say, if I get the amount I asked for, I screwed up. Like,
Yeah.
I didn't ask for enough.
Sure enough. But this part, man, could you imagine if the jury heard this? Holy shit.
I think the jury would be like slashing her tires.
If the jury heard this, and they can't, one, the questions being asked, this is in the context of a proffer. They would not be asking in this fashion. you would see a very different tone. But two, here's the thing, two, why didn't they? Because this is protected. This is Chapter 39 immunity. The investigation, this is immunity. You know that qualified immunity we talk about with officers, how they can't be sued?
Yep.
This is that. That's where we are. This is that realm where it doesn't feel right. It doesn't feel right. But it is.
Pull all these people in, including Dr. Kirkpatrick, including Dr. Hanna. I think they testified in the dependency action. And if the judge decides that there's serious question about whether I'm right, then the court makes that decision based on the evidence that they receive. That's not my job to litigate the whole thing and put out all of the potential possibilities in the case and say, I'm the child abuse pediatrician, but I don't really know if there was child abuse here, because in this case, there clearly, in my opinion, was child abuse here.
Yeah. So you did not put in any of the conclusions or any of the data from Eagle's Wings and those therapists and psychologists that saw the Kowalskis, did you?
There was a licensed clinical social work intern who saw Maya and her family at Eagle's Wings. And I don't honestly know where that was in the pile of records when I was writing up my report. I kept writing part of the report, having to do other things, writing part of the report, having to do other things. And I inadvertently did not include that in my report.
Well, you did research it enough to realize that Rebecca Johnson had a master's degree and over 20 years of experience as a therapist at Eagle's Wings. Did you not?
Well, the question really in terms of my part
I'm
is
just
whether
asking you if you knew that or not, man.
I knew I'd have to look and see exactly what her credentials were. I'd certainly, defer to you if you're reading her credentials off. But it's irrelevant unless she did the whole thing I did, looking at all these medical records and has expertise in medical child abuse, for her to be able to say one way or the other if there was child abuse or not.
Okay. Look, did anybody agree with your assessment that there was no CRPS?
Yes, I believe they did.
Who?
I believe that there were multiple people in the hospitalist that didn't think she had it. And I believe that although there was probably some question about whether she might have some sort of amplified pain.
For those of you wondering, I'm doing a very special live stream on Saturday. That live stream on Saturday is with Spidey from the Behavioral Arts. People have asked about the behavioral panel and why they haven't reviewed this. Well, Chase Hughes is a friend of mine and a friend of Spidey's. Behavioral Arts is a behavioral analyst. That last question and her answer to that.
Oh, I mean, you don't need a behavioral analyst. You could
No,
just
you
see
don't.
that one and be like, she is clearly bullshitting, right? So,
oh my God.
Yeah.
Yeah. So Saturday, live stream with Behavioral Arts. I'm going to pull the testimony and we're going to have some clips and we're going to go over some of it. But
Disorder, the pain management team didn't think she had CRPS.
Well, amazingly enough, we did have Dr. Elliott in here to testify, and he never said that she did not have it. None of the doctors so far testified, A, that they were experts in CRPS, or B, that she did not have it. Are you aware of that?
No, I'm not. I wasn't supposed to watch any of the testimonies. So I have no idea what people talk
Gather
about.
that. From your investigation, though, at the time, did it come to your attention? Nowhere in any of the records did anyone who had any expertise in this, that is a pain management doctor, a neurologist, or an anesthesiologist, ever agree with your assessment that there was no CRPS?
I think I just answered that. Yes, I believe there were people that had the same opinion.
Okay. What did you check with Dr. Spiegel, a board certified neurologist that treated Maya and confirmed CRPS?
objection assumes facts, not an evidence.
Go ahead and answer.
Dr. Spiegel had this 10-year-old child do hyperbaric oxygen treatment, I believe, on 40 occasions in a row when she also got ketamine on some of the same days. So I wasn't terribly worried about whether he thought or did not think that she had CRPS.
At least she says the quiet part out loud. At least she does that. That's the thing. Like, thank you for saying it. You know, Dr. Sally Smith, thank you for at least saying it. Put it out there. Like, say, no, I didn't find their assessment credible. Thank you for saying it. Like, people can disagree, but at least you said the quiet part out loud.
Because you'd already decided in your mind that a board certified pediatrician with his years of experience was not qualified to render an opinion on that. Is that right?
Objection misrepresents the credentials, and I asked a comment on another Crumbill no witness.
Go ahead and answer.
The hell was that objection? Mr. Hunter, I've got good ears, but that was a lot of mumbling.
Into
I'm
the
sorry.
mic.
Dr. Barr,
Yeah.
a board certified neurologist, he testified and confirmed CRPS. Did you put that in your report?
I don't know that I specifically said that he said that diagnosis. I think, as I recall, without going into the stack, that I did say in the history that Dr. Kirkpatrick had diagnosed her with that. Those people might have had that opinion. I don't think, based on my review of the CRPS literature and discussions with physicians since then, and in the context of all the evidence that there was of medical child abuse, that Dr. Barr's opinion, if that was his, that she had CRPS, was reliable.
Okay, so now Dr. Spiegel is not reliable, and he's a neurologist. At least will you agree that neurology and anesthesiology are the two areas that are most involved in the investigation of complex regional pain syndrome?
I imagine those are people that typically evaluate and treat patients with complex regional pain syndrome, sure, but not all neurologists and pain management or not all neurologists or anesthesiologists are, if you will, created equally. There are some who.
Not all neurologists and anesthesiologists are created equally. Okay, I get it. Thank you for saying the quiet part out loud. At least someone has. At least someone has.
She's like,
All
I
the
think
other
these guys
doctors
are
in this
idiots.
case
I'm
have
the
been-
smart person in the room.
Well, they've been dodging it. They haven't been going and saying that guy's full of crap or that guy's full of crap. They've been dodging it. Like, thanks for saying the quiet part out loud.
Who practice at a very high level. And when I, having reviewed medical records from all kinds of providers all over the state and even other parts of the country for 35 years, read through information and see all the supporting information that they have and compare that with other information that I gather in my medical record review, I can assess whether the person that, you know, made thousands of dollars was reliable or not. And I didn't find those people to be particularly reliable in terms of their diagnosis, even though I certainly included their information in my report.
Dr. Hanna, a anesthesiologist with over 25 years of experience in treating CRPS, you didn't put his confirmation, or excuse me, he did a diagnosis of CRPS in your report either, did you?
I believe in the history, I made reference to that. Yeah, I'm pretty sure I did say that he, made that diagnosis. But this is a doctor who was giving a child, a 10-year-old child who was on the small side, 1,000 milligrams of ketamine anywhere between 8 and 32 milligrams of Versed, doses of Zofran, 1,750 milligrams typically of magnesium, all at the same time in an outpatient setting with no documentation of vital signs. And there was indication in the records that appeared to me to suggest that the family member was the person monitoring the pulse oximeter. So that person, to me, is not particularly reliable in terms of whether this child needed the treatment that she was getting, whether he had made an accurate diagnosis or not. So I put his information in my report. Yes, I discounted his diagnosis.
And of course, you discounted Dr.
She's mad.
Cantu's confirmation of CRPS.
Well, I never got any records from Dr. Cantu, so I couldn't really address that whole situation other than from the WordPress blog. This person put a 9-year-old child in a ketamine coma for days. It took her probably about a week to just be able to be discharged from the hospital after that.
So
I didn't find him reliable from what I saw.
All right. So if I'm understanding you, the fact that 3 different treating anesthesiologists specializing in CRPS, 2 different neurologists specializing in the treating of CRPS,
Watch your eyes.
you know more. Fair?
I don't know more. As I said, I looked at their information, and based on what was done with this particular child, I did not find their opinion to be reliable.
And who elected you to be the judge of whether all of these board certified physicians were reliable?
Nope.
How argumentative of a question could you get? Like objection argumentative times a million.
He's just loving that he's got free reign to be a dick in this. And she wants to kill him.
Oh, these two would be, that'd be fun.
I mean, yeah, she's got clear hatred in her eyes here. I would just recommend that if he gets sick, he needs to go to a different hospital.
Oh, no. Oh.
Nobody. I presented it to a real judge who made a determination.
Well, isn't it true, ma'am, that you are not a medical investigator? You are, in fact, a medical prosecutor.
That's absolute nonsense.
Because an investigator would include both sides of the story and let the judge decide, right?
No. The Child Protection Team medical director will assess whether there's medical evidence to support a diagnosis of child abuse, and then the dependency attorney will present that to the judge.
Wait.
So this is actually a big problem because this is like an ex parte application, right?
What? Yeah. Wait. What?
Oh.
Did you and I both like kind of put our fingers at the same time? By the way,
I think so. Because there's an obligation when you're doing like an ex parte thing to present both sides, to like present. And she's saying, no, we only present one side. That's a problem. That's a really big problem. That's not how this is supposed
I want
to
to hear
work.
that again. That was
Oh my God.
You guys, it might, for those of you who think that like this is me like expressing bias.
No, this is a giant problem. And if I was the lawyer who presented this in court, I would have an email waiting for her in her email box when she got back to the office. And it would be something along the lines of, we can't use your reports anymore.
Ever.
Like, I cannot present your stuff in court. I have an ethical problem with that. So, figure that out.
That's like a cop that comes upon a scene of a murder and sees a guy holding a gun, right? And documents this guy is holding a gun, right? And
Yeah.
submits that for the application. But what he left out was as the cop was arriving, he saw another dude hand the guy the gun.
Or, one thing that gets, like for drug warrants, one thing they'll say all the time is, we saw somebody come to the door and do a hand-to-hand transaction. That, and so that might be accurate, but the cop can't leave out that the hand-to-hand transaction was that the person who came to the door gave him a pizza box and took money and arrived in a car that says Domino's, because, that's shading things, right? You have to present both sides. Oh,
It's the framing. It's the framing. This is if this is how she approached every case,
it means there may be a lot of cases out there that are injustices.
well, there was one, Ian, where a dad was incarcerated incarcerated for 300 days. That ended up being overturned because he got acquitted because of this medical child abuse.
Yep.
And it was actually her case. He confronted her when she was walking into the courthourhouse.
That's a bad idea, by the way. Don't confront a witness.
Oh, it was, and
showing up for court.
And then yeah. So don't. You can protest. You can exercise your First Amendment right to protest. Maybe don't confront a witness as they're walking into court.
Yeah, that could be confused with an attempt at witness intimidation, and
tackled real quick.
Yeah.
So, yeah. Okay, well let's see if we can't hear that answer again, because I need to
really address that whole situation other than from the WordPress blog. This person put a 9-year-old child in a ketamine coma for days.
Yep.
It took her probably about a week to just be able to be discharged from the hospital after that.
So
I didn't find him reliable from what I saw.
Okay.
All right. So if I'm understanding you, the fact that 3 different treating anesthesiologists specializing in CRPS, 2 different neurologists specializing in the treating of CRPS, you know more. Fair?
I don't know more. As I said, I looked at their information, and based on what was done with this particular child, I did not find their opinion to be reliable.
And who elected you to be the judge of whether all of these board certified
Such a dick
physicians
question.
were reliable?
Nobody. I presented it to a real judge who made a determination.
Well, isn't it true, ma'am, that you are not a medical investigator? You are, in fact, a medical prosecutor.
That's absolute nonsense.
Because an investigator would.
Could you imagine this in front of the jury?
I also just love how she thinks she's throwing this back in his face. She's like, I got him. And this is good lawyering. He already knew what she was going to say. And he was already ready to transition that into the next line of questioning.
If you're the jury, you're doing this. You're going,
oh, if I'm the jury, I'm probably not doing that. I'm probably setting my piece of paper aside and just going, we done. Because
I'm grabbing popcorn and just watching, like, oh, they're fighting. Oh, they really don't like each other.
The most damaging thing a jury can do isn't when they're sitting there writing like intently. That's bad for the other side. It's when they go and they just set their book down entirely and they're like, this is the moment we've decided. We're done. everything is good. We already have our answer and nothing's going to change our mind. We don't need notes about this. F this guy. That's the moment that, and they could have been doing that if this was what was happening in front of them. So she makes me mad.
Aaron Hack she thinks that line was the best line. Thank you,
She
Rob, for
does.
passion and humility. And congrats on 200K. By the way, Anderson calling Sally Smith as a medical prosecutor, best line in this trial by far. You hit the nail on the head. Outside the presence of the jury. But he has wanted his shot at her for a while.
This is just one of those moments. I think you were mentioning, like, you get a witness where you're just like, I want to go after this witness. And sometimes it can be really annoying. I had a witness in a criminal trial where I was like, I want to rip this witness to bits. And the Crown was like, I'm not calling that witness. And I was like, but I want to destroy that witness. And I mean, ultimately it was a good thing, because the reason why I wanted to destroy that witness is so that the court wouldn't put any weight on their evidence. So if the court not hearing their evidence is even better than that. But this is like so satisfying to watch, because I know just how much he's loving this.
My frustration is her mentality, which I think is Anderson's frustration. That's my frustration, her mentality.
Oh, it's like I get to go after somebody I consider a real villain.
And it's not really, I'm not viewing it in the yes, this case is significant. I see that, but I'm viewing this person in the context that they have this authority.
Yeah.
And my head goes to the next case, the case after that, the case after that, the case after that, the case that ends up on my doorstep where I have a client coming to me and this is the person I have to face off against.
And sometimes you just hope that her day to day is so bad that she thinks about it the next time. And that it causes maybe a little bit of humility.
Her depots were bad. She had a USA Today article written about her. Crazy Cat Queen posted that earlier.
Can we get the depots?
Yeah, I can get them.
I kind of want to go over her depots.
I've got clips of the highlights from the stuff that was played for the jury. I can send that to you. I'll send it to you. Actually, I can share that to you right now.
I mean,
but I'll play this right now.
Just like beginning to end.
Both sides of the story and let the judge decide, right?
No, the child protection team medical director will assess whether there's medical evidence to support a diagnosis of child abuse, and then the dependency attorney will present that to the judge. And the other side gets attorneys also. There were 5 in this case, and they present all the information, and then the judge tries to decide, whose information is more reliable.
That's what he just said, though.
Here,
you are a
under oath,
prosecutor,
are
not
you
an
telling us,
investigator.
Are you an investigator?
She's describing the job of a prosecutor.
Are you a prosecutor?
I am
of
neither.
The information.
I'm a medical doctor who is an expert in child abuse pediatrics.
Mr. Anderson, I'm giving you very wide latitude. I'm done. You're finished? Okay. Mr. Hunter, anything further in Proffer?
Very briefly, Rob.
I'll give you a little.
Dr. Kirkpatrick, and he warned you off. Did he tell you that he had last seen this child 10 months before the conversation?
I honestly don't recall if I already knew that. I might have already known that.
And when you wrote your report, you had the Tampa General Hospital records, the Lurie Children's Hospital records, the All Children's records predating October of 2016, correct?
Correct.
And all those hospitalizations with all those specialists that saw this child, do you see any of them suggest that CRPS was the diagnosis?
No, and multiple were experts in complex regional pain syndrome.
Thank you.
So when the lawyer is like, I'm done here.
Yes.
Okay, Madam Court Reporter, note that the proffer is now closed. Dr. Sally Smith, you had looked at a little report during your testimony. Can you hand that to
Yes.
me? I'm going to hand
And
it to the
you can
clerk.
keep it if you want.
Okay, I'm going to hand it to the clerk. Let's mark it as whatever the next number for plaintiff for ID purposes. And just tell us what that number is. So the report that Dr. Smith looked at during her testimony in front of the jury is ID'd as 2804. It's not in evidence. May,
I'm sorry, I think you said in front of the jury, I think you meant not.
no, earlier during her testimony, she had pulled out a report, and that is what we just identified. Now, does Dr. Sally Smith, is she released or does she need to remain under subpoena?
She's released by plaintiff.
Released, Your Honor. So you can watch them.
Oh, she
You are
gone.
released. You are
see that?
no longer
That's a smile. That's a smile of someone who knows she's gone.
Yeah. The other thing is when the lawyer is like, I'm done. You know, when the judge starts giving some pushback, it's because he knows he already got what he wanted. And for the last few questions, he wasn't getting anything new. He was going over that same tread. He was just kicking her when she was down. He's like, this is the point where I just get to use you as a punching bag. And when the judge is like, she's had enough, he's like, okay, but he wasn't fighting it because he already got what he wanted.
Yeah.
That was just recreational after that.
It was. Oh, he was being a jerk. They both
Oh,
were.
yeah.
They were going at each other. That was both of them. They did not like each other at all. Yeah. So, we already hit jury questions already. So I've got to catch up on super chats and get out of here because I have to be in court at 9:30 tomorrow morning.
Oh, you have made some terrible mistakes today.
Ian, come on, my friend. You know that I have made terrible mistakes. You know I have, but I'm
you
too
hit
into this trial.
You hit 200,000. That's a big day.
I did. It's really cool.
Congratulations, man. It's well deserved, and you'll be at 250 in no time.
Thank you, buddy.
I'll race you, and you'll win, but I'll race you.
Okay, you jumping off?
Yeah, I'll let you. I'm gonna keep you up until like wherever, because I will tangent. So I will let you wrap this up, just so that you're not too bagged in your trial tomorrow. So
thank you.
Congratulations again, and have a good one,
bud. Thank you.
Bye.
Well, that was a pleasant surprise. That was a very pleasant surprise indeed. So I'm going to do this. I'm going to wrap super chats up. There's a lot of them. I can't get to. You guys were flooding the chat. I'm going to try to get to as many as I can. I promise you. I'm going to try and get to as many as I can next 15 minutes. But then I have to wrap because you could tell my voice is starting to go. That little cough I was fighting off last week, it's starting to come back. And I don't want it to come back. So Caroline Ciano, Jay Hatch's decision to allow Smith to continue was surely deliberate. Do you agree with the doubling down strategy, Rob? They had to. Ashley L., what happens if the jury hears outside the court about any of this? They get excused from the jury. That's a problem. Like if they watch the Netflix documentary, or if they see the Facebook group about removing Sally Smith's medical license. Are they allowed to be on the jury? No. Removed. And it's a possible mistrial if they've been communicating with each other. So I really hope they're not. Hallie P., I saw your follow-up super chat. I had this one starred too. I know I'm behind. Why isn't her investigation initial participation considered fruit of the poisonous tree? It seems so fair that she got to be on both teams. The second one, why is what the docs did being taken out on the parents? Also, why isn't her involvement fruit of the poisonous tree? evidence is different in juvenile court proceedings than it is in criminal trials. I think that's the best way I can explain it. I've never seen judges give more excuses for allowing evidence in than in juvenile court proceedings. A lot of it's justified, but it's tough. I'm not sure why it wasn't excluded. I don't know. So why is it being taken on the parents? I don't know. The parents here kind of, they became unruly. They did. Dr. Malik the afternoon, Dr. Malik, just to summarize, he was a treating physician, actually stood up and said in the PICU or in the ICU meeting, we have to treat her like she has CRPS. I found that phrasing interesting because the premise is that she doesn't. But he testified that Beata's demeanor was not unlike other parents that he has disagreed with as far as treatment plans. I thought he was credible. He and I disagree when it came to when discharge is permitted, AMA, against medical advice. But hey, that's for the jury, not for me. But by all accounts, Maya Kowalski at some point in time did become a force, a person that became very difficult for the hospital staff to deal with. And I can see how the hospital reached their conclusions. I mean, like I said, for me, I'm torn on a lot of the issues except for a few of the specific incidents. But again, I'm just giving recaps and assessing what I'm seeing as I'm seeing it. Happy Annie, can parts of depots be played during closing? No. No, they can't. You can recount testimony. You can't play the depot. Mary, because that gives more weight to a witness's testimony than you can otherwise. Mary Corlade, besides Beata's claim, do you think the plaintiffs have put a convincing case for the other claims thus far and or defense has counteracted effectively? I've been kind of clear on this one. I think the Beata's claim is the toughest one. I think false imprisonment, they've got okay. The battery on the photos. Kathy Beatty shows up on Monday, so I want to listen to her first. I want to hear her. Some of the other stuff, the accessing the medical records beforehand, I have issues with, and the medical billing, I have issues with. KK, wouldn't asking for updated labs help give more info and clearer picture? Possible. Steeler with RSD, Rob, can her attorney tell her how to answer? You can prep them, but you cannot tell them what to say. Casey Cat, for the doctor, they played depot today. You cannot demand medical records from a patient family, especially when they've told you they don't want your care anymore. So the doctor was asking for that before the transfer to Nemours. You can refuse to treat them, but you can't say we'll hold you till you do. These are part of the things that I think the Kowalskis have the strongest case for. Just Sarah, thank you, Rob. I had undiagnosed PTSD, PPD, anxiety, etc., and I'm struggling when mine were little, but I've never hurt them. Sally Smith is why all docs terrified me back then. Wrong doc, wrong day, and question. Everyone is one bad day away from being on the wrong side of a system they don't understand and can't fight. Caitlin Fletcher, can we get a side-by-side video? I'm going to try. I'll try. Sharon Davis, why did they focus on Munchausen's and not entertain the thought that Beata might be using daughter's meds? Oh, I don't know. Marianne, agree. When Dr. S said all meds and dosage, I understand. I think the MD giving all that needs investigated. It would kill an adult. He billed for that much, yet not give it. Cash only, suspicious. That's a take. I think the dosages were high, but again, I'm not a doctor. Kristen, what time Saturday? Because there is something at 2. I will take that into account. I still have to confirm that with Spidey. I'll let you guys know. Jesse, rah. Third option, yesterday's possibly coach witness. That's coming back tomorrow. OB nurse, Chelsea, is it proper how Anderson's been implying to the jury the defense is improperly communicating with witnesses. It's a double-edged sword. I think for me and my taste, he's gone too far. He's gone too far. I understand that with a couple of witnesses, with ones that are difficult to get around, you ask the question, but you talked to the other side, didn't you? The thing is, there's a jury instruction that says they're allowed to, and you can't infer anything bad about that. For me, I'm done with it. He needs to stop that. I don't like it. I think it's starting to be shady lawyer-ish. Just my opinion. Amber C, I've heard a lot about privatized CPS during this trial. How does their funding work in this county specifically? I don't know Pinellas County. I don't. Amber Hayes, can the remaining 6 jurors that will deliberate keep the notes from the jurors that will not deliberate? No. Jurors recall their own information in their own notes. Nancy Joe Mo, will the plaintiffs run out of time? Yep. It's a question of whether they do it at the end or before the end. AG, do you think the jurors whose questions are excluded are coming to any conclusions from that? I don't know. Lucifer, congrats on 200K. Been having a rough few weeks and your coverage has helped me through. I'm sorry you've been having a rough few weeks. I'm glad the coverage has helped. Can't say thank you enough. P.S. Does anyone else think Miss Crowell's sounds like Judge A? She does. The voice does. I'm there. I heard it the first day. Deb D, does this open her older CPS up for review? I don't think so. Too far in the past. Miss Megs 31, question, do proffers count against time? No. Casey Lewis, if Sally Smith requests a brain scan, who pays? Very expensive. That's an interesting question I didn't thought of. That's a very interesting question I didn't think of. If any of the stuff being suggested by Sally Smith was done, who's footing the bill for that? Because if it's done by DCF in the course of the investigation, you would assume that's a state cost, right? Hang on. Let me think this through for a second. If Sally Smith, because she just testified, right? She testified that she would recommend things to be done that would further or assist the investigation. If those things that she recommended would, in furtherance or assistance of the investigation, those should be state costs. But if they ended up on the patient's billing sheet and were submitted to the patient's insurance provider, wouldn't that contradict what she was saying? That's a very, very curious question. And I don't know the answer to that, but I wonder if the plaintiffs would go after that. Interesting. Very interesting. Great question. Solo YOLO, tell Ian about the guy. I did. Mom 06, thank you for the very generous super chat. Colorado versus Stotch case, county clerk fired for leaking the documents. That's what I mean. You cannot access things that you cannot access. Congrats, Rob. Airborne a day keeps the sore throat away. I use 7-Up, retired teacher. Thank you, Mom of 6. Very much appreciated. I will take that advice. Amy Downey, question, can this help the defense on appeal? They're going to argue it back and forth. Hey, it's Maddie. I forget. Will the transcript of this go to the jury? Nope. They have to remember the testimony based on their own memory. Little Raven Wolf, she sent innocent dad 300 days. And who are you? I commented that to Ian. Lion by the sea, might legal problem now. She admitted for the past cases. Probably not. The redhead, my job at DCFS was to determine if abuse occurred or not. She tries to find abuse every time. I do anything I can to not tear families apart. That redhead, thank you for entering the chat, because that was my point. If your investigation for DCF or for CPS or whatever agency is there, your investigation is tasked with finding whether this thing exists or it doesn't, not with aiming at an end. Thank you for that input. Keenan, she destroyed this family after hiding important facts. Shame, shame, shame. People have that opinion. Maureen Griffin, family members manage pulsometers all the time. Plenty did it during COVID. I have no medical degree and did it. She's so unbelievably arrogant. People have that opinion as well. Inelegant. Is there no misconduct investigation or corrective action? She no longer works there. Beach Rando, based on this, can others use this testimony against her or J Hatch? Yes, they can. Testimony in open court under oath can be used against you at any time. SF in Texas. Are there any possible repercussions from what SS said in this trial? Further cases where it gets brought up, but realistically, they settled out. They settled. Sally Smith and Suncoast settled $2.5 million. I'm young, but isn't Sally Smith immune regarding her report? The report is immune. That's correct. That is why they were making that proffer, because they disagree with that. Mary Liebrecht, you really need to watch the documentary after the trial. Mickey Duff, why the defense agreed to this proffer? They wanted the proffer. They need the proffer because they wanted that introduced. Claire Willis, if this goes to appeal, will a jury get to see it? Appeal is judges, not jury. LJ Peach, okay, Rob, my head just exploded as a parent of a special needs child who needed large amounts of meds, screaming at ED doctors who refused to listen to me and written standing orders I carried with. And that's the other side. So when I say the doctors had a reason to be concerned, they do, but also, why are you just throwing out other orders? It's a good question. The little birdie, thank you. At the end of the day, can you imagine this jury watching this after the trial is over? Oh, God, I hope not. If they do, hi. Catherine, thank you for the super sticker. Daisy, thank you for the very generous super chat. Congrats on 200K, Rob. I remember subbing on your first day around 1600. So cool to watch how you've come and how far you'll go. Emma Daisy, thank you. That is exceedingly kind of you. And thank you for following along and for, just enjoying kind of the path. We're still learning and we're still figuring stuff out. Holly Pate, I think parents with sick kids get desperate at a point, especially when people/docs don't listen. My daughter was sick and it took 9 months for anyone to listen to me. They thought I was crazy. I understand this. Yes. I think there's a very good point there. Maureen Griffin, I struggled at the beginning because I thought Anderson sounded like Poot. Sometimes. Amber Hayes, if Maya was in the custody of the state, shouldn't they be footing all the medical bills during that time? That was my question. I'm now curious about that. I'm very curious about that question. I would go after that angle. Casey Cat, Rob, doesn't matter. Court DCF would require the parents to maintain health insurance and pay for their child's care. Oh, that's a good point too. But the investigation itself, I think, is different. I got to look this up. I got to figure this out. I'm going to try and look that up tonight. No, not tonight. I'm going to look it up tomorrow after court. Court. Die Hard HTTR, hail to the Redskins. USA Today article, bad medicine all over Sally Smith and Florida DCF bad practices. Thank you for that. Check that article out. LS, thank you for the super sticker. Matt, Smith actively trying to rip families apart instead of ruling everything out is earth shattering. I had a difficulty with that as well. You guys, thank you. Thank you for being here. Everyone is yelling at me to go to bed. I do need to go to bed. We're going to end the stream before midnight. Thank you guys so much. We hit 200,000 subscribers. We did. You guys did. Thank you. It's really pretty cool. It means the world. It means the world. E. James N84 coming in late. I believe the father who was incarcerated was seeking to sue J Hatch and SS. This was mentioned in Recovery Addict Stream. Yes, it was. I did. So please go check that out. Please go check that out. Okay, guys, I'm going to call it quits. On the way out, I'm going to do something and go ahead and play the outro, which is a reminder to all of you, something that kept me sane, keeps me sane every single day, every day. Make something, you'll feel better, whether it's writing, whether it's drawing, whether it's crocheting, knitting, I don't care what it is, woodworking, metalworking, do something with your hands, disconnect from a lot of the stuff that we see on a daily basis. It will make your life a little bit better. It's kind of why I'm still here. My love goes out to all of you. Thank you for following along. Good night. God bless. And I will see you guys tomorrow night.